My lord, may I be permitted to mention one urgent matter, lordship. In earlier occasion, the matter was taken up by your lordship, and your lordship was pleased to release the matter due to determination. And subsequently, lordship, the matter has been assigned before your lordship by the Honorable Chief Justice. Lord. In earlier occasion, I have mentioned, as your lordship was not sitting on that this week, so lordship was pleased to fixed on 14, but lordship may it be taken up by today or tomorrow, lordship.
Why today? It was
not
fixed on
not today, lordship, tomorrow. I am asking for the
why?
Because there are certain urgency, lordship, because the matter is already pending for last 2 months. Now, lordship, my
2 months it is pending. Now you are showing urgency.
So far the matter
It is fixed on 14.
So far the matter urgency of this matter is concerned, lordship, that I am the eligible candidate who have applied for the new vacancy in respect of a new vacancy. Now, lordship, that's my so far my instruction is concerned, lordship, it will be awarded to someone else, lordship, if my matter is not been taken up, lordship.
It has already been awarded. What is the
My
urgency
Latin
now?
senior has appointed, lordship, Mr. Sahara will argue in this matter, lordship.
I understand the issue, but when one person has already been appointed,
not appointed, they are to be appointed, lordship. And during pendency of the matter, lordship.
Since 2 months you are roaming from the
lordship,
day,
because
now you are showing that there is urgency. Because of that, I am sitting in this week.
In lordship, lack
Okay.
of
Come on Monday then. Come on Monday,
Lordship.
not this week.
lordship,
No, come on Monday.
So lordship has Monday on Monday.
Monday.
Lordship, may I permitted to mention, Lordship?
Another
The
innocuous
matter is ready for hearing and affidavit in case complete, Lordship.
Let him finish.
for on prosecution, lordship. On prosecution. To be mentioned. Careful, dear.
Just senior is on line. Was there anything mentioning like that? Mr. Mukherjee is there online.
Yes, I am waiting for item number 1.
Okay, just wait. Let them
A permit to listed motion 2022 land, group 1.
Group 1. Yes. What is the matter?
The matter is ready for hearing, Lordship. Affidavit in case is complete, Lordship. Lordship, the employment of petitioner belongs to extreme category and the petitioner in the interest of the petitioner stolen land, sir. Lordship, kindly permitted to.
The matter, group 8 matter.
Yes, Lordship.
So what do you want now?
Ready for hearing,
Speak,
Lordship.
please
Matter has been filed 2021. Yes, Lordship. Out of lease, Lordship.
Very good. For listing.
Grateful, Lordship.
This is concerning termination. It's a group 8 matter, my lord. The pleadings have been completed. Now the difficulty is there is an imminent threat because it was completely a violation of natural justice, my lord. First of all, I am humbly seeking so far the matter can be taken up because my
For listing.
my lord, it's already in the list. I'm seeking.
Already in the list.
I'm seeking
What is the
upgradation,
number? This number?
my lord. It's 122, my lord.
Yes.
122, my lord. Amit Kumar Thapa versus Indian Oil Corporation.
122.
122 in the monthly list, my lord.
122 for hearing.
Oh, yeah, my lord. Any day, so if your lordship pleases, my lord.
Yes, you are for the petitioner.
I am for the petitioner, my
Who is
lord.
for the respondent? Indian
IOCL is,
person.
my lord, Indian Oil Corporation.
Readings complete. Everything complete. Right. 24th, 23rd. 23rd. কি আছে 2 PM এ কিছু আছে কটা আছে আর কিছু নেই তো ওকে আর কিছু নেই তো ঠিক আছে বসুন item number 122 please take down on mentioning item number 122 this matter be listed on 23rd of July 2025 at 3 PM as a specially fixed matter.
Grateful, my lord. One more indulgence. Another motion, my lord, if I am permitted to mention, this is a precarious situation because there is already a
Running in the list?
running in the list, my lord.
Motion number?
Item number 89, my lord.
89.
89, my lord. Tushar Gandhi. My lord, there is a partnership dispute in respect of which there is
89.
89, my lord. Tushar.
If it is not taken up today, tomorrow.
Grateful, my lord.
My lord,
Yes.
Under compelling circumstance, I'm mentioning, my lord, item number 74 of today's list, my lord. My lord, third rounds of litigation, my lord. Last occasion, your lordship was pleased to pass the order, my lord.
On the diary first, thereafter I will take up the matter.
My lord,
If not taken up today, tomorrow.
my lord, tomorrow, my lord.
May I have your lordship,
79.
Okay.
79 at your number?
No, 74, my lord,
74.
my lord.
Yes.
That's my lord.
upon putting notice to the other side, madam, may I permit to mention item number 46, 47 of the today's list. 47, group 8 motion, my lord.
It will taken up today, no issue.
But if it is not taken up in either way, my lord, kindly take it up tomorrow. Some urgency involved.
46 and 47.
Only 47.
Only,
Third column,
only 47.
47. In any case, my lord, it is not taken up, my lord.
Okay.
Kindly give some preference tomorrow. May I hand it over the slip?
Not necessary.
Lordship, may I be
Mark.
permitted to mention, my lord, a contempt matter of your lordship's list, my lord, pertaining to circuit bench Jalpaiguri, my lord, for inclusion in the list. Because your lord,
In Jalpaiguri contempt matter.
my lord, of your lordship's order, my lord, contempt of your lordship's order. So in the circuit bench, my lord, before mentioning, your lordship came here and the bench sitting there refused to entertain because your lordship is sitting. Contempt of your lordship's order in circuit bench, my lord.
Listing.
Grateful, your lordship.
Okay.
Yes, item number 1.
Okay. I beg to appear, my lord, on behalf of the petitioner.
Yes.
Kindly have a look at the list of dates. On several occasions in the past, the state was not appearing.
I oppose this, my lord. স্যার আপনি যেটা বলছেন সেটা ঠিক নয় প্লিজ সি দা my lord, please see the order sheet. Please see the order sheet. Why that allegation? Sir, আপনি আমাদের allegation করছেন।
ভাই অর্ডার শিটে দেখতে বলেছি, আর কিছু বলিনি। অর্ডার শিটে কি আছে দেখা।
অর্ডার ডেট আসেনি।
No, Mr. De, this matter is pending since 2010.
My lord, 10 or 12 or 25, that is not the matter. Whether this is correct or not.
What?
Whether Mr. De was not appear on the date when the matter was called in. That is the matter, my lord.
এই অরিন্দম,
You last appeared on January 2025. Thereafter, May, you did not appear. No report is filed on behalf of the state.
রাগ করছেন কেন স্যার? রাগ
This is the
করবেন না,
issue.
সকালবেলা
আরে যা
বর্ষাকাল।
order sheet এ যা লিখেছে না,
না না আরে
এই এর কে কপি দিয়েছে।
আপনার থেকে আপনার তো অ্যাপিয়ার করছেন না।
স্যার বলেছেন বলে অন্য কেউ বললে আমি করতাম না। স্যার বলেছেন বলে
এই
স্যার
তো করে দিয়েছে।
স্যার আমাদের বাড়ির এখন হচ্ছেন অল ইন অল। স্যার
স্যার,
কেবল
বলি,
ফাদার অফ
Okay, okay.
আমি কোনোদিন স্যারের বিরুদ্ধে বলি?
আমি কি বলেছি? আপনি এত রাগ করছেন কেন? বর্ষাকাল।
So one report is required to be
একটা
filed.
report file
No, my lord, no report is necessary.
হ্যাঁ?
As this petition is not maintainable.
আচ্ছা ঠিক আছে।
Very well. So I am taking
Yes,
up
my
your
lord.
submission.
ব্যাস।
No report is required. I am taking notes
Yes, my
and
lord.
fixing a date of hearing.
Yes,
Any
my lord.
date-
If you are ready
Any
to.
day, my lord, any day.
Any
Not
day,
at
any day.
10:30, my lord.
I'll
Any
tell,
day,
acha, very good.
not at 10:30.
Whatever time suits my learned friend, no difficulty, but the day, my lord, let it be as earliest as possible.
তুমি আছো, তুমি
We can
আছো,
even start today.
তুমি আছো?
We are ready to start even today.
My lord, any day, my lord, your lordship
Any
can
day
fix the
includes
matter.
today.
Not
We are ready to start.
10:30, my lord.
আরে okay.
Not 10:30.
Yes, my
হ্যাঁ
lord.
স্যার বলুন।
My lord, kindly record it that the respondents are not willing to.
Yes,
file any-
file any
I'll
affidavit.
record it. I'll record it.
This,
record.
that's all.
Okay.
ঠিক আছে, ও কোনো চাপ নেই।
Please take down.
আরে বাবা না না স্যার
ঠান্ডা ঠান্ডা। আরে
Mr. Chondi Charan De, learned AGP, appearing on behalf of the state respondent,
হ্যাঁ, নিশ্চয়ই।
submits that in this matter, the state shall not use report or affidavit against the writ petition. Considering the submission, it appears that the matter can be heard at any day. Accordingly, so
After 2 days, 3 days, whenever it is convenient to your lordship,
8:30 better for
10:30 হলে সবচেয়ে ভালো কি হয়? সকাল সকাল।
আমাদের হয় না আমাদের
একটু- তা ঠিক আছে
বাবা আমার তুমি তো জানো আমি প্রতিটা ঘরে যাই
তাহলে একটা পাসওয়ার্ড নিয়ে নেবেন, আবার চলে আসবেন। 12টা হলে কি হয়? একটা অন্য মামলা চলছে, সেটা এবার কন্টিনিউ করলো 1:45 অবধি, তখন কি হয়? পুরো জিনিসটা সবার আটকে যায়।
Hey, died in. 16 তারিখে 16 16 16 তারিখে
Solo.
হ্যাঁ, 12টায় কোনো ফিক্স আছে? 12:15,
Yes, yes.
15, 16, next Wednesday.
Yes, my lord.
16 তারিখ স্যার, পরের বৃহস্পতিবার।
Grateful lordship.
Wednesday.
ও ওয়েনসডে, পরের বুধবার। 16 তারিখ 12:15টার সময়।
It's all right. I'll be there.
Okay. কি বললাম বলো? Let the matter appear in the list on 16th of July 2025 at 12:15 as a specially fixed matter.
Grateful to your lordship.
Call next matter.
Obliged, your lordship.
We are for the respondent opposite party. The lordship was hearing the application, my lord, regarding payment, their demand for payment of occupational charge. Mr. Chaturvedi has addressed your lordship.
Yes.
Fix any time, lord, at 2 p.m. Your lordship lord was hearing this matter. Next week, Mr. Moinak was appearing. Any day, next week, any day 2 p.m. They have to reply because my lord, Mr. Chaturvedi has made his submissions regarding my lord, contractual rent and my lord, occupational charge.
They have to reply.
They have to reply.
Mr. Chaturvedi is there. So,
Mr. Moinak Bose is to reply. Mr. Moinak Bose is for the respondent petitioner. He will reply. He will reply.
Okay. Mr. Kallal Bosu and Piyush Chaturvedi for the appellant.
They are leading me.
Yes. So, now issue is that this matter appearing in the last week, I think.
It appeared last week, my lord. Your lordship.
I told you that if they would
Let it appear next week. Because they were not present on that day also.
Yes.
Today also they are not appearing. Kindly fix next week any day, my lord. We shall intimate them.
You just inform.
My lord.
Otherwise, not
Yes.
possible.
My lord.
Let the matter appear in under the same heading.
If possible at 2 p.m. my lord, because the lordship was.
Let me find out. তেইশ তারিখ দুটোর সময় 23 তারিখ দুটোর সময় ফাঁকা হবে দুটোর সময় কিছু কাজ দিয়েছি 24 তারিখ দেখুন না 24 তারিখ 28 তারিখ 28 তারিখ 28 তারিখ 28 তারিখ দেখুন 28 তারিখ আচ্ছা তাহলে এটা 28
28. As well as.
just wait 29 তারিখ একটা 29
29.
Let
Mark
the
as
matter
2 p.m. 2 p.m. My lord.
let the matter appear in the list on 29th of July 2025 at 2 p.m.
At 2 p.m.
Applicant is directed to inform the petitioner, inform the respondent.
Respond. My lord. Much obliged.
So they record them.
This was
Yes,
Take your breath. Take your breath.
29.
Lordship, it was fixed on 14th at 2 p.m. I had mentioned that day. Lordship had told on 14th at 2 p.m.
After that, the matter was appearing in the list. It was taken up. They were not present. Your
Lordship may
fix-
kindly do it at 14th because we were told that Lordship is not sitting till
Domnino.
Just take your breath.
Take your breath.
Don't have to hurry.
আগে সপ্তাহ ছিল তো বৃহস্পতিবার ছিল ওনারা মিস করেছে
Lordship, we can do it on 14th at 2 p.m. or tomorrow. 29th is too long.
I fixed it today for hearing. because this week is very easy week for me.
Lordship, then tomorrow 10:30.
Tomorrow I have fixed some matters. This is the,
Today at 2 o'clock we will come.
no, 2 o'clock I have fixed some matters.
12. Today at 12.
Right.
Lordship, just I would pray that 29th is too
14
long.
14th টা দেখুন তো, 14th টা, close to that. Okay, very well. Let it be on 14th at 2 p.m.
Much obliged, Lordship.
14th at 2 p.m.
Much obliged.
14th of July. Item number 12:30. 3/4/12:30. Next.
My lord, with your lordship's kind leave, my lord. Item number 5, we beg to appear for the petitioner, my lord. If I may apprise your lordships, my lord, on the previous occasion, my lord, it was a leave matter. The state sought for time, my lord, to take instructions, my lord. Your lordships was kind enough, my lord, to give them time fixing the matter today, my lord.
Yes, you start.
Yes, my lord. The petitioner before your lordship is an applicant for an EMA dealership, my lord.
Yes.
Vide a notification which was issued, my lord, on 15/5/2024, appearing at page 14 of your lordship's brief, my lord, as annexure P3, my lord. My lord, pursuant to this application, my lord, an inspection was conducted, my lord, vide a notice, my lord, which was issued on 22nd of May, my lord, appearing at page 19 of your lordship's brief, my lord. Thereafter,
Yes.
no, my lord, that is the acknowledgement slip. Page 20 is the, my lord, I'm sorry, my lord, is the inspection notice, my lord. After that, my lord, nothing was communicated, no inspection was held, no notice was given, my lord, no notice for, my lord, interview was given in terms of the notification appearing at page 21, my lord, to the petitioner. Now, my lord, last time, lordship had a query, my lord, whether the petitioner at all was eligible or not to get the call for interview.
Yes.
Now, my lord, in that respect, my lord, I have twofold submission, my lord. If your lordships kindly have, my lord, the notification itself, my lord. The notification, if your lordships kindly have, my lord.
Yes.
My lord, the relevant will be page 15, my lord, which is part 2, the eligibility criteria, my lord, paragraph 8, my lord. If your lordship sees Roman 4, my lord, requirement of size of Godown and shop for running ration shop, my lord, at page 15.
Yes.
Yes, my lord, may kindly have Roman 5 onwards, my lord. May I place it, my lord? My lord, the applicant applying against a vacancy of fair price shop must have a ready Godown as per the above norms on the date of inspection. However, my lord, this is important. However, if the Godown is otherwise ready, following deviation exceptions at the time of inspections may be ignored, my lord. Now, kindly have A after that. If the structure of floor, wall, and roof of the proposed Godown is complete and floor is otherwise ready, but titles, cement, finishing is not done, or if the bitumen coating is not done in case of roof covered with asbestos sheet tin, then Godown will be treated as incomplete, but application should be processed, my lord. In such case, minimum marks should be given for such Godown, my lord. Now kindly takes B, my lord. On processing of the application in cases of incomplete Godown, if the applicant is otherwise found to be eligible, my lord. My lord, I am emphasizing if the applicant is otherwise found to be eligible, my lord, and all other criteria of engagements of FPS dealer are fulfilled, license will be issued only after further inquiry and uploading or photo regarding completion of tile, cement, finish or bitumen coating as the case may be. Well, let's see. However, if any of the wall or floor or ceiling roof is incomplete on the date of inspection, the Godown will be treated as incomplete, my lord. And the application will not be further processed. My lord, this is where I am, my lord. Will not be further processed, my lord. It will be marked as incomplete Godown, my lord. It will be marked as incomplete Godown in the portal, my lord. So, my lord, if they had any doubt or my ineligibility regarding the Godown, my lord, it was incumbent upon them, my lord, to show as incomplete Godown in the portal, and size and picture as on the date of inspection will be uploaded. So that was their duty, my lord, to do it. However, no marks will be allotted against such applicant. He will be treated as ineligible, my lord. So, my lord, if the contention of the state, I don't know, if is such, my lord, that I was ineligible as per Godown, my lord, then it was incumbent upon them, my lord, to put it up in the portal that I am ineligible. So I would not be expecting a further call of interview. But, my lord, I made a specific prayer that that is not the case. On 18th of June, when I checked the portal, my lord, it was showing as under processing, my lord. And, my lord, if your lordship sees, my lord, I have made an averment to that effect, my lord. If they can demonstrate before your lordships, no, that is not true, my lord. They have marked me as ineligible in the portal on the very same day or thereafter, my lord. But before 18th of June, my lord, then I don't have a case, my lord. But if that is not, my lord, then my specific contention before your lordship is that, my lord, I have not been given a call for the interview, my lord. And the eligibility and the most suitable candidate list has been published, my lord. That your lordship will be pleased to find in your lordship's brief, page 23, annexure P8, my lord. This is on 25th of June, my lord. On 18th of June, my lord, it was under processing. On 25th of June, my lord, it has been marked. I have been marked.
Page 23.
My lord.
Page 23.
Page 23, my lord.
What is this?
My lord, this is the from the portal. It has been taken off the page, my lord, which shows, my lord, this private respondent number 7 has been allotted license, my lord, in respect of the vacancy, my lord. If your lordships kindly have the license number, my lord, along with the name and FPS code, my lord.
Yes.
My lord, this I have come to know, my lord, on 25th of June, my lord. Thereafter, I came before your lordships, my lord. Your lordships was gracious enough to permit me to come day after, my lord, when the state sought for time, my lord. My lord, kindly have paragraph 8 at page 5. I have averred, my lord. Regularly checking, my lord. Lordship have it, my lord. Paragraph 8, my lord. And I am placing it, my lord. Your petitioner states that although no intimation was given to the petitioner either about the interview to be held in terms of subclause 3 of clause 20 of the 2013 order, my lord, or of the allotment of license, and the petitioner kept regularly checking the portal for the status of allotment of license, and on June 18, 2025, when the petitioner checked the portal, the status showed as processing. But when 25th June 2025, the petitioner revisited the portal, it showed that the license has been issued in favor of the private respondent number 7, my lord. So, my lord, I am running a specific case, my lord, giving date, my lord, particular date, my lord, when it was showing as processing, and on the date, my lord, which showed that, my lord, license has been issued, my lord. So this is my sum and substance of my case, my lord.
Okay. Yes, Mr. Chatterjee.
Lord, first of all, he is not at all entitled of interview because he is not qualifying the minimum criteria of Godown. My lord, the petitioner's Godown is 207.86 square feet, and the attached shop is, my lord, 76.70 square feet. My lord, as was the specification of the notification is the mandatory minimum 300 square feet, and total 200 and 100 is required on the minimum criteria. But at the threshold, his application should be rejected on the ground, my lord, if having comparative charge, my lord, or sees. The left column, my lord, as a measurement of the Godown, the office area 207. It's not your documents, it's the official documents. 207.86 square feet and 76.70 square feet respectively. However, the measurement of the office come go down not fulfill GO 1467. Hence, this application is not eligible, my lord, at all. And following the observation regarding the ineligibility of the applicant, minimum required go down specifications not matched. The minor mismatch is there on the ROR on the applicant's name and no support affidavit produced declaring both are the same person. That is minus my effect, but that's the major one, my lord, is go down not fulfill the basic criteria 300 square feet and 100 square feet and so forth,
Yes.
my lord. That is the minimum. Even there's my lord, the license was granted, my lord, and the allotment was given, my lord, and he is in full fledged. If my lord was pleases, then I'll come with an report, inquiry report, and others, my lords. And there is no scope of interim order, my lord, at this stage, my lord. And I'll come with a report, my lord.
So you don't have the sufficient area in the godown.
My lord, that is what their contention is. My contention is, my lord, if I did not have the sufficient area, my lord, they could have marked me ineligible. There was nothing in their way, my lord, coming in their way to mark me ineligible in the
My
portal.
lord, I haven't also.
They could have done it, my lord. What was so suspicious about marking me ineligible, which they are
report is
entitled as
also
per their own advertisement, my lord? They could have marked me. I would not have come before your lordship. I would not have checked regularly the portal, my lord.
No inspection done in your in present your
Yes,
present.
yes, my lord. They could have told me. They could have given me a writing in that you are ineligible.
Yes, they have given you the copy of inspection.
No, my lord. Copy of the inspection is given, but not marking me as ineligible is my specific instruction. If it is otherwise, my lord, then obviously my client will suffer the consequence, my lord.
It is not an usual practice. Everyone will given the intimation that you are not eligible, you are eligible, but that is not usual practice, my lord.
My lord,
That is from the server and the
I
intimation from the.
My lord, if they have produced a copy, they must also have produced a copy of the land in which I
Initial
the
one prima facie is not entitled, my lord. If my lord was pleases, then I will come with the entire report within a form of affidavit.
They could have marked me ineligible, my lord. There was nothing coming. This is
You
what.
know you are
That
not
is
eligible.
that is
eligible.
not the ground
My
for
lord, I would not have
interference.
applied if I have known I am not eligible, my lord. I would not have applied for the first place, my lord.
As the prima facie hasn't
You know your area of your godown. You know your area of your godown. You must apply with your specific area of godown. You have
Kindly
no
have
area of godown.
page 15, first paragraph, my lord, at the top. If they are saying that I am ineligible at the threshold, my lord, then they could have invoked the clause 7, my lord, of this notification, my lord, which says I'm placing, my lord. Incomplete application or application received after. Incomplete application is what I am on, my lord. Or application, my lord, this last part. Or application received from ineligible applicants will be summarily rejected.
Forget about whether they are doing or not. You know your godown is whether they are saying incorrect.
My lord,
the area of your godown is otherwise, then I can entertain only.
Clause
Otherwise
4
not.
specifically
If
seek
you
that
know
the
this is the
applicant should
notification,
possess a godown, my
vacancy
lord.
notification,
So from
and you have
godown,
placed
my
a godown below the area
minimum
of
criteria
vacancy.
he has to possess those godown, my
My
lord.
lord, that is upon me, my lord. I
Yes.
completely bow down, my lord. That is upon me. But on
If
the
you
other
are
hand,
challenging that the area,
my lord.
if you are challenging, then I can entertain. Otherwise, not. You have to challenge that their area is not special. What they have stated is not correct.
My lord, I have not got a copy of that, my lord.
Your client has got the copy.
My lord, he has marked.
Yes, he has signed it. He has received the copy.
Oh, there. Oh, my lord. Then that is not.
Yes, that is the situation here.
Then I
Nowadays, they are all taking the signatures and all copy has been handed over at spot.
kindly give me one short date, my lord. Place it in normal in the list, my lord. I'll take instruction and come back, my lord.
Very good. Please take down. A short report is placed on behalf of the land, on behalf of the state. Full stop. The sole contention of the state authority that proposed SOPCOM go down of the petitioner is not fulfilling the and area thereof are not fulfilling the vacancy notification. That's why they could not proceeded the application of the petitioner. The state respondent also placed the copy of report of inquiry of proposed outcome Godown of the petitioner. They also the report of the petitioner, report of the state also annexed a copy of receipt of such report by the petitioner. Considering the situation, the petitioner, learned counsel for the petitioner, is to take instruction from the petitioner. Let the matter appear in the list under the same heading on 15th of July.
Well, I'm grateful. Madam, can I have a copy so that I can take instruction of the report?
You should have a copy.
Only inquiry report, my lord.
Yes. Do you have another copy?
Yes, my lord. Xerox sheet and I giving you.
Mr. Chatterjee, learned counsel appearing on behalf of the state respondent, is to serve a copy of the report upon the learned counsel
The
appearing.
inquiry report, my lord. Only inquiry report.
Copy of inquiry report
I'm extremely grateful, my lord.
upon the learned counsel for the petition.
Extremely grateful.
Grateful, my lord.
Okay, thank you. Next. Next. Okay, you are for the petition. Yes, Mr. Sara, you are here.
My actually 7. My
You are-
7.
Next. Pass it over. Next.
I am for the petition.
Your
Yes.
Lordship, Mr. Shishwana Bandyopadhyay is appearing for the state, but Your Lordship, he's on his legs. So I'm
Start my lord, because your lordship may remember this matter was taken up on the last date of vacation. Some
Okay,
urgent-
okay.
Your
Two
Lordship,
matters are there.
I'm,
This matter was not taken up.
Yes.
I'm praying for
Sir,
a
sir,
short accommodation, Your
Sir,
Lordship.
I have been impaneled. Allotment is not being made in so far my rice mill is concerned. That's the urgency. Everybody has been gone. Your lordship may remember other matters. Your lordship also passed the order. One
Two matters are there. One matter I
Yes,
passed the
yes.
order,
One
but
matter
this
has already
matter
disposed of.
objected to. Highly objected.
Matter
That's why the
objected.
matter was fixed for hearing. So
কালকে বলবো আপনি বলি আমারটা বলি মানে let I conclude my submission and tomorrow maybe otherwise it will take some time. Some urgency.
then you take note.
Take note.
You take note. Is it possible for you to take?
Yes, Your Lordship, but
okay.
my instruction is that
No, no, আজকে
to take a-
conclude হবে না.
to take a note today. Kindly keep it some other
Now,
day, Your
tomorrow is
Lordship.
first matter, another heading to be mentioned. Mention matter, first matter. Okay, not today.
Grateful, Your Lordship.
Not today থাকে এমনি। Mention matter 1 নম্বর থাকে।
I'll get much of it.
Yes, next. One is there. Not today. Next.
I'm for the petitioner, my lord.
But I appear for the alleged contempt.
This matter was taken up on 15th of May, my lord. The lordship has directed me to serve on them and file an affidavit of service. This matter,
Papers দিন। কাগজগুলো দিন।
Yes, my lord. This matter, my lord.
Yes.
My application under section 10, my lord. This has been filed against the receiver, my lord, appointed by the 7th bench of the Learned City Civil Court, my lord. In this matter, my lord, what happened, my lord, I had purchased a machine, CNC lathe machine, for my business purpose. I am a proprietorship concern. I had purchased the machine. The machine was worth 38 lakhs, out of which I have paid 11 lakhs as down payment. And the rest of the money, my lord, I had taken finance from a finance company called Electronica Finance Limited. My lord, in that matter, I had purchased the machine, finance was completed. This happened, my lord, in December 2021. Subsequently, I was paying the EMI, I was using the machine. My lord, suddenly on July 2023, my lord, it was pointed out to me that I am paying interest, my lord, on the whole amount of 38 lakhs instead of 27 lakhs, deducting the interest portion, the down payment portion, my lord. So, my lord, I wrote to the finance company and there were certain disputes regarding the quantum of interest, my lord. So, after that, my lord, I stopped paying the EMIs. I have instructed specifically in writing to my bank, do not pay the EMI, and that copy of the letter was given to the finance company also. So, certain disputes crept up. My lord, suddenly, in November 2023, a receiver along with police personnel came to my premises and took possession of the machine, and they informed me that there is an order under section 9 of the Arbitration and Conciliation Act against me for taking possession of the machine. So, my lord, I was not aware. It was not informed to me. So, my lord, I filed a letter of objection saying that no order has been served on me. Anyways, on 29th November, my lord, they took possession of the machine and took it away from me. Lord, I have a leader, Lord, Mr. Shakkoshan. He is online. He can be allowed to be joined.
Yes.
Yes. So, my lord, machine was taken away. I immediately entered an appearance before the City Civil Court. And by an order dated 12th of December, my lord, by an order dated 12th of December, my lord, the court directed the receiver not to take possession. But, my lord, by that time, possession has already been taken. So, my lord, thereafter, my lord, I filed a recalling application before the City Civil Court. On 21st of December, my lord, 2023, my application was allowed.
Recalling application.
Recalling application was allowed. My lord, on contest, they had filed a WO, there was a contested hearing. My recalling application was allowed. Receiver was directed to return the machine within 7 days. So, from 27th of December to 7 days, my lord, 21st of December to, my lord, 28th of December. My lord, what happened, my lord? Receiver did not comply with the order. In the meantime, on 29th, that is the next day, when the machine was supposed to be returned, on 29th, my lord, the finance company moved an appeal against that order before the vacation bench. In the vacation bench, my lord, they could not procure a stay. Court reopened on 2nd of January. My lord, I am told upon instruction subject to correction because lower court records are here, my lord. The receiver filed a report on 2nd of January before the court below, stating that since the finance company has gone in appeal, that is why I have not complied. But that is subject to correction from the records, man. So, my lord, I wrote to the receiver through my advocate saying that you have not complied with the machine. That letter was received by the receiver on 3rd of January physically in Calcutta, my lord. After receiving there was still no compliance. After that, my lord, I filed this contempt application on 11th of January. My lord, subsequently, there are certain events that has happened, my lord. If your lordship kindly takes, receiver has written to me, my lord, on 19th of January, my lord, saying that it has been kept in a godown of a third party and they're asking for 3,60,000 payment for loading charges, handling charges. So if you pay the amount, then I will hand it over to you. So, my lord, that was not what was directed to the receiver, my lord. So, my lord, if I can just show the order of appointment of the receiver, my lord, kindly takes page, my lord, 67.
And I am sorry to interrupt my learned friend, but actually I am appearing for the learned receiver.
Yes.
But I am in some difficulty today. If your lordship permits, I can be before your lordship tomorrow and argue the matter.
No, when petitioner has started, let him
Yes,
finish.
let
me place one.
My reply can be given tomorrow if your lordship permits.
No issue.
Obliged, because actually I have a difficulty today. Okay, obliged.
Well, kindly takes page 67. I'll take down the notes, my lord, and I'll share
Yes,
it.
you take them. Page
67, my lord, of my application.
Yes.
Yes, my lord. Learned advocate of petition. This is the section 9 order where the receiver was appointed. Peruse the petition supported by an affidavit, the documents annexed. Requisites at once, 12/3/2020 for SR. My lord, this is important because no requisites were filed by them. At the time of hearing, learned advocate of petitioner places a prayer for appointment of receiver in respect of machines. My lord, this is the subject, this is a property concern. Machine being one ACE slant bed CNC lathe model LT2 LM 1500 complete with controls, FANUC, OITF with all standard accessories manufactured by the dealer ACE Designers Limited. Now, my lord, kindly takes after the next paragraph, my lord, at the bottom of the page. Accordingly, Shouvik Bishas, learned advocate, be appointed the receiver for the purpose of taking possession in respect of the machines. So and such with all the description is there. And the next paragraph, the petitioner and the learned receiver is directed not to sell the machines without the order of the arbitrator. Learned receiver is to comply with the order 40 rule 3 of CPC. Receiver is authorized to take necessary steps in accordance with law so long as the machines in question shall remain in the custody of the receiver. He shall remain responsible for any loss or damage, if any, caused to the said machines. So this was the order which was subsequently served to me where the receiver was appointed. So my lord, after my recalling application was placed and it was heard on merits, my lord, recalling order was passed, my lord. The order which I am alleging that has been violated is at page 26.
Page
26, man. Starts at 27, man. This is the order where the receiver was directed to restore the machine to my custody.
Your recalling application.
This is the order passed in my recalling application, and my lord, this order has been violated according to me. This is a missed case under section 9 of the arbitration. Petitioner has filed stating inter alia that the machine being is such and such with all standard accessories manufactured and dealt with by ACE Designer has been repossessed by order of this court dated 9/11. According to the respondent, on 29/11, the receiver removed the said machine from the possession of the respondent. Respondent also stated that it came to know about the order only on 28th of November when the learned receiver came to his place to take possession of the machine. By way of the said petition, learned advocate for the respondent inter alia plead for directing the learned receiver to restore and return the machine being such and such along with all standard accessories to the respondent. The respondent stated that the petitioner has not complied with the mandatory provision of Order 39 Rules 3A and B of CPC. Petitioner filed written objection questioning inter alia the maintainability of the petition. According to the petitioner, the respondent failed and neglected to comply with the terms and conditions of the agreement, especially as to the payment schedule. And I heard both sides. By order dated, this court authorized the receiver to take possession of the said machine. It is an undisputed fact that the possession of the machine has been taken by the receiver. It appears from the order that the said order was received by the receiver was not allowed to sell the machine and he was directed to return the machine within 60 days from the date of the order if arbitration proceeding was not initiated within 60 days. From the submission of the learned advocate of the parties, it appears that till today, no arbitrator has been appointed. The order was passed on 9 November 2023 and only a few days are remaining. Apart from that, it further transpired that requisite was not filed by the petitioner as per direction of this court. The objection of section 9 is to preserve the property in the interest of the persons interested in it. Learned advocate for the respondent submits that the receiver has taken possession of the machine, defeating their objection. Court has not authorized the learned receiver to take possession of the machine applying any force. The learned advocate for the petitioner submitted that the respondent has willingly handed over the machine to the receiver. But from the fact that the respondent has appeared and raised objection to taking such possession signifies that the fact that the receiver has taken possession of the machine without considering the objection. Considering the said fact coupled with the fact that the petitioner has not filed the requisites for information about the order, it appears to me that it would be proper to return the machine to the possession of the respondent. However, the respondent should not be given a free hand in this regard. For the protection of the property, it is necessary to give direction upon the respondent not to sell the property without the permission of the court or to encumber the same in any manner whatsoever in view of section 9 of the arbitration. Thus, the learned receiver is directed to return the machine to the respondent within 7 days from the date of this 7 days from the from this date and submit a report to the court within 7 days. Receiver is directed to deposit, respondent directed to report such and such. Let a copy of this order be sent to the receiver. My lord, kindly take the bottom part after the signature of the learned judge. Received copy, Shouvik Bishwas, 21st of December. There is an endorsement, my lord, that he has received on the same date. My lord, in spite of that, it was not complied with. When it was not complied, even after 28th, that is after 7 days, my lord, my advocate wrote to him stating that you kindly comply with the order, which is at page 87, man. 87.
Yes.
Yes, ma'am. Please find enclosed a copy of the order dated such and such, whereby you were directed to hand over the machineries to my client within 7 days from the date of passing of the order. However, the same has not been complied with. You are requested to comply with the said direction immediately, failing which I have instructions to initiate. My lord, here also there is an endorsement, my lord. 3rd of January 2024, Shouvik Bishwas, he has received it by hand. My lord, subsequently, certain events have happened after filing of the contempt application, my lord. The receiver has sent me an email, my lord, to my advocate.
It should have come by way of an affidavit.
Well, kindly takes the.
You serve a copy to him at
Yes, I've given.
Okay.
Well, kindly take, my lord, 19 January towards the middle of the page, my lord. On Friday, 19 January 2024. Lordship has got it, my lord? Towards the middle of the page. I, Shouvik Bishwas, advocate receiver in this case, state, I have been directed by the learned judge City Civil Court to hand over the above machine to the respondent, which I intend to do once I return to Kolkata after attending my ailing mother, staying at my native place at village Bhulot, PO Asharu, PS Bongao, District 24 Parganas, pin such and such, and has undergone surgery on 26th of December. Well, this is 19 January. He is informing me for the first time. Hence, please make arrangements to transport the above subject machine out of the Godown. It is kept under my custody at SS Industries in such and such place in Domjur, Howrah. The proposed date of such action is on 22nd of January, almost a month later, my lord. Kindly let me know your convenience so that I can command the concerned persons accordingly. Now, my lord, kindly take the top part of the page, my lord. Then again at 11:33 p.m. on the same day, he is writing, please find the trailing mail. You are requested to address the issue immediately and keep me updated so that I can hand over the said machine as per direction of the court. My lord, what is the trailing mail? My lord, right just below that. Kindly make payment of 2 lakhs as per my email immediately. So, my lord, he is asking for payment now for complying with the order of the court. Secondly, my stockyard shall remain closed from 21st of January for operation, and I shall not be present in Kolkata on 21st Jan and hence cannot help you at the moment. I shall return to Kolkata and be available at my stockyard. Well, this is being written by the person who is the owner of the property where the machine is kept. Thirdly, the amount of 1,60,000 towards loading, unloading, crane charges, transport charges also remains unpaid, which was arranged by us at your special request. Please effect immediate payment of the same. Fourthly, I think you must ask all parties involved to ensure that my charges of 3,60,000 is paid. So, my lord, hurdles are being created so that order does not have to be complied. Subsequently, my lord, this was on 19 Jan. Machine was supposed to be handed over to me on 22nd Jan as per this communication. Subsequently, my lord, on 25th of Jan, this machine was handed over to me in a damaged and broken condition. My lord, this is a report that was filed. Oh, well, this is a report that was filed after 25th of Jan. The machine was handed over to me. I had to arrange for transport. Machine was damaged, and my lord, no accessories was handed over to me. So in an incomplete manner, machine was given to me without the accessories, my lord, to the effect, resultingly, my lord, machine cannot be used. This was in 25th of Jan. Order was supposed to be complied with by 28th of December. My lord, this is the report of the receiver. May I read it, my lord? Pursuant to the order dated passed by the learned 7th Judge City Civil Court, the learned court was directed to return the machine being such and such, along with all accessories. manufactured by the dealer such and such, which was in my possession from 29th of November 2023 in a safe premises situated at such and such, Domjur, Howrah. The learned causer directed the receiver to return the machine within 7 days from passing of the order dated such and such, but due to my mother's surgery on 26th of December, I couldn't comply with the order. Hence, I already reported to the learned judge regarding my mother's illness on 2nd of January through my second receiver report. That by an email dated 21st of January informed the learned advocate for the respondent to come to take the machine from the previous mentioned premises by his client. That the owner of the premises is asking for rupees 1 lakh cost as charge of his Godown rent for shifting, and for the same, a bill is already issued on the learned receiver's name, being dated 1/12/2023, which was already been annexed with my first report submitted to the learned judge, City Civil Court, Calcutta. After entering the premises, I told the respondent to check their machineries and direct the owner of the premises to open the cover, which is covered the machine. Thereafter, the borrower checked the machine and said, okay. Then I asked to take the machine and call the crane, and they do so. And my lord, then he's saying that I have already handed over the machine. That on 25th of January at around 8:30 p.m., I am handing over the machine being slant bed such and such, along with all accessories manufactured by the dealer to the respondent, namely Shantanu Samantu, in front of the learned advocate, but the respondent refused to affix their seal and signature as a token of receipt and took away the asset as it was with them. So, my lord, what has happened here is that, my lord, when the machine was being returned, I had to give him a receipt saying that I have received all the documents. So I was making an endorsement at that point of time that I have received the machine. Whatever had actually happened, I have received the machine in a damaged condition without the accessories. So, my lord, that was not allowed. He said, if you do not write that you have received the machine as a whole, you do not have to give your endorsement. So I have not. So there is no endorsement on my part in this, either in the report or in the minutes of the meeting on 21st of January, which was not, no copy was given. Subsequently, my lord, after this incident happened, my lord, my advocate again wrote to him saying that you have not given me the accessories.
Lord, may I just indicate something? Lord, he is handing over papers like anything. Lord, these should have come by way of a supplementary affidavit.
Well, this has happened in a subsequently.
So subsequently,
Okay,
events should have come as a
let
supplementary
me
affidavit.
hear it out. Okay.
Yes, my lord. Well, lord, this is the email, my lord, which my advocate had written to him, recording the fact that the accessories was not given. Well, upon hearing of the parties, learned civil court had directed the petitioner as well as you to sell the machine, not to sell the machine without the order of the court. Thereafter, on 21st of December, the learned court had directed you to return the machine to my client within 7 days from the date and to submit a report before the court within 7 days. At first, the machineries were to be handed over on 22nd of January, but however, such machineries were ultimately handed over on 25th of Jan at the premises where the machineries were kept by you. But unfortunately, on 25th of Jan, instead of 3 p.m., you had visited the premises on 8 p.m. and had made my clients wait for 5 hours. In the meantime, my clients were being informed that the machines had not been kept in a proper condition pursuant to the instruction of the learned court on 9th November 2023. My client has also informed me that the machines were already sold to another party. It is pertinent to mention that the order dated has not been complied with since the machineries were delivered without the accessories, which includes the controller, fanuk, and other accessories. So, my lord, my contention here is, my lord, this is the list of accessories, my lord, which has not been handed over to me. So this order, my lord, has till today, my lord, not complied with.
How can I verify these are the machineries? These are the accessories attached with the machine.
My lord, when the machine was taken custody of, your lordship will find a reflection in the order, which I had showed, my lord, along with all accessories.
Yes,
along with
these accessories were there.
Yes, my lord.
So how can I ascertain now?
Yes, my lord. When the possession was taken, the receiver has filed a report saying he has taken the machine along with all accessories. But when he is handing over the machine,
what? All the matters.
My lord, this is the list of accessories, my lord, according to me, which were missing when the machine was handed over to me.
Whether it was already there at the time.
It was already there, my lord, which is recorded in the order, my lord, when the receiver has taken possession.
I understand all the accessories. What does it mean? I do not know.
My lord,
because we are not the expert like that.
Yes, my lord. Well, according to me, my lord, this is the list of accessories which was not handed over to me.
Very good.
So that is the situation, my lord. Till today, it has not been complied with. My lord, let them show that they have handed over all the accessories. There are 2 points to be considered here, my lord. Order was dated 21st of December 2023. It had to be complied within 7 days, which is 28th of December 2023. Admittedly, my lord, machine in a damaged condition, although in a damaged condition, was returned to me 21st of January 2024, almost after 1 month. So, my lord, that period of willful violation of the order, that has to be explained. And secondly, my lord, where the accessories are, which have still not been returned to me, that part has to also to be concerned. This is my application.
Very good. You place those documents on record by filing supplementary.
I will, my lord. I will.
Let them place it on by filing supplementary affidavit. Lord, let me, may I file my opposition to both the petition and the supplementary affidavit? Let him file the reply. Lord, only after that your lordship will take up the matter.
Very good. Learned counsel, during course of argument, learned counsel appearing on behalf of the petitioner. Placed on record, now intends to place on record some subsequent events. Those events are material to decide the issue in hand. Accordingly, the petitioner is directed to file a supplementary affidavit placing on record the documents. Let the supplementary affidavit file within a week.
Well, 2 weeks.
Within 2 weeks from that, reply against the supplementary affidavit as well as against the contempt application be filed by the alleged contemptor within 2 weeks thereafter. 2 weeks. Let the matter appear in the list under the heading hearing on 5th of August. 2 weeks, 5th of August. Yes.
Lord, one more, Lord. Liberty may be granted to the arrest contemptor to file his vakalatnama, Lord. We'll do it in course of the day.
You can place vakalatnama with the department. What is necessary to file in this matter? কোনটা এটা মেনশন করে সার্কিট বেঞ্চে তো আসবে তো রেকর্ডটা না এখানেই হবে রেকর্ডটা না affidavit of service file be on behalf of the parties taken on record. Yes.
May please, your lordship, my lord. This is my contempt petition, my lord. I am filing my affidavit of service, my lord. 10 and 11, my lord, both are same.
This is Messr Sonai Food Marketing. Whether appeal is pending in this matter? They have said earlier occasion that the appeal is pending.
But appeal, I have not received any copy of appeal till date. Moreover, my lord, your lordship kindly go through this judgment, my lord. Even if appeal is pending.
Even if appeal is pending, the matter can be there.
My lord.
My lord, we preferred an appeal, my lord. Please take some more time, my lord. 3 weeks time, 4 weeks time.
You have not given the number at least, Mr. Agarwal.
Also, I'll supply the number. Yes. 2 appeals has been preferred, my lord. One.
I'll affidavit to the contempt petition, my lord.
But give some more time, my lord.
Cannot be a ground for.
Give at least 4 weeks time, my lord. I will come.
4 weeks, how can it be? You mentioned the appeal.
Lordship, I will.
Mention the
In the
appeal,
meantime, lordship, kindly adjourn.
I can adjourn for 2 weeks only.
Instead of 2 weeks, kindly give
you have to mention the matter.
3 weeks, kindly.
At least mention a day.
Lordship, we'll mention.
Before the division bench, whether it will be taken up or not, that is up to division bench. At least you mention after notice.
Lordship, I'll mention. Kindly adjourn it. Lordship, I'll serve copy, man.
We serve a notice at least.
So by this time, let them file their affidavit to the contempt petition. I am not asking for rule. At least they can make their statement in the.
So kindly accommodate us on 3 weeks, my lord.
And by this time, if appeal is heard, they can annex that order.
Instead of, my lord, passing any orders, my lord, kindly adjourn the matter. 3 weeks, I'll come, my lord.
Give me the number at this appeal number.
My lord, kindly consider this judgment, my lord.
Yes. appeal number 3.
Two separate appeals is my lord filed, my lord.
Separate appeal.
Affidavit of service filed on behalf of the petitioner is taken on record. Mr. Amritalal Chatterjee, learned counsel appearing on behalf of alleged
Led
contender.
by Mr. Nilatpal Chatterjee, my lord.
My lord, you kindly record that their review application has already been rejected by law. Recalling, my recalling has already been
It
rejected.
is on record.
Yes,
My lord,
that's all.
let it appear in this order also, my lord. It is my submission, my lord. Let it be submitted.
Okay, I will take your submission.
My lord.
কি বললাম বলো? Submit that an appeal being number MAT 879 of 2025 has been preferred by the state against the order under contempt. So he prayed for some time so that the matter can be heard by the Honorable Division Bench. Mr. Agarwal, learned senior counsel appearing on behalf of the petitioner, submits that in this matter, one order of recalling was filed by the state respondent, which was turned down by this court. Thereafter, the state respondent has proceeded to appeal, which is come to know to the petitioner for this day only. No notice has been served upon the petitioner for filing of the appeal. However, Mr. Agarwal also submits that by virtue of decision of Honorable Apex Court in Dr. H. Punindra Singh and others versus K.K. Sethi and another, the Honorable Apex Court has reported in within bracket 1998 8 SCC 640. The Honorable Apex Court has held that the contempt application should have been disposed of on merit instead of adjourning the same till disposal of the appeal. Full stop. Having heard the learned counsel for the parties, also considering the relevant observation of Honorable Apex Court, it appears that the state has already prepared an appeal against the order under contempt. So merit of the contempt application would depend upon the result of the appeal. Concerning the same, the petitioner, the state respondent is directed to move the appeal before the appropriate division bench as early as possible, so that the instant contempt application, which is pending since law, may be disposed of in its logical conclusion. Accordingly, the matter may appear in the list on 28th of July. 28th of July under the same heading. The state respondent stroke alleged contemptor are required to mention this matter before the Honorable Division Bench after supplying a copy to the petitioner.
My lord, it appear as to be mentioned, my lord, because your lordship has granted him. It is appearing today as contempt petition.
It will again appear a complaint application. Only 3-4 contempt applications are there. Let them appear.
My lord, the next matter is similar matter. Only appeal number will be different.
Two appeals, my lord.
Second man number 878 of 2025.
Lords.
My filing affidavit service.
Yes. Same order.
Grateful, my lord.
Affidavit need. Affidavit need.
Grateful, my lord.
I filed this contempt petition for non-compliance with Lordship's order dated 3rd January 2025, my lord. And we come to the ordering portion, my lord, the page 61, my lord. Six, 60, my lord, the fine observation, your lordship, my lord, paragraph 90, my lord, 19, and thereafter, my lord, the ordering portion from paragraph number 20, my lord. Under the above circumstances, I think necessary direct the respondent to decide to implement the necessary structure of pay and other terms and conditions of the service of the present petitioner by virtue of the memo dated 557 dated 2nd September 2010, and thus the writ petition is disposed of. And thereafter, my lord, there is a direction liberty to approach for us to the concerned authority with the representation, my lord. And thereafter, my lord, there is a direction to consider that in light of the paragraph number 20, my lord, regarding the fixation of pay, my lord, pay structure, regarding pay structure, my lord, I have accordingly made representation, my lord, on 20th January, and my lord, thereafter, after expiry of the statutory period, your lordship fixed up the stipulated period, my lord, the concerned authority passed the reason order, my
Where is your representation?
my lord, representation in light of the paragraph, my lord, kindly come to 70. My representation is, my lord, last representation for contempt I have filed on 7th April, my lord, and before that, my lord, I have filed another representation in view of the order passed by your lordship, my lord, is page 63, my lord. Page 63, my lord. After over the statutory period, my lord, the concerned authority passed the order, my lord, reason order, my lord, which is completely violation of your lordship's order, my lord. They are as if sitting as an appeal court, my lord. This order, my lord. It is another contempt, my lord. As if they have reverted all the findings made by your lordship, my lord. They didn't prefer any appeal, but they have controverted all the findings of your lordship, my lord, in this case. Reason order, my lord.
So they have passed a reasoned order.
Reason order, my lord.
So you have to challenge that order.
My lord,
not
what
by
happened,
this
my lord? They
contempt
have
application.
contempt, act of contempt, my lord, in double score, my lord. There is a, my lord, kindly come to paragraph number 20, my lord. What's your lordship's order, my lord? Your lordship order, my lord, page 60, 61, my lord, to pay, to fix up a pay scale, my lord. And in view of the order, paragraph 19, your lordship's observation, my lord, that we are doing service.
So if you are in opinion that they have passed an order, which is called reasoned order, but not in following the direction of
this court, my lord.
So you can prefer an writ petition for that, not for
My
the
lord,
contempt.
My lord, but they have to pass the order in view of the order passed by your lordship, my lord.
Whatever
They cannot
may
act,
be.
my lord. They cannot
But
act.
that is not taken into consideration in the contempt application.
My lord, but
contempt application is very limited scope. You know that.
My lord. But they have to comply with the order, my lord. Paragraph number 20, my lord, your lordship's order, my lord. In view of the...
That is the merit.
My lord.
That is the merit of this matter. So you have to file a writ petition on that.
After, my lord, they have passed order after filing the contempt petition, my lord.
That is altogether issue. Okay. Okay. So when they pass the order? On
24th, it is service. It is served on 28th, my lord.
24th of April.
April.
So direction was that after filing the representation, 8 weeks.
8 weeks, my lord.
So 2 months was given to them. January, February, March. So after 24 days they have passed
my
this
lord,
order.
my lord. And it is
So when you were heard
on 28th, my lord.
28th of March.
April.
No.
20th
You
of
have given a hearing.
hearing. They have given a hearing.
When you given the hearing?
My lord, hearing was given on hearing notice.
Twenty-eighth of March.
My lord, 28th of March, my lord. 28th of March, they have given hearing, my lord. But my contention is that, my lord, it is not, the reason order is not in view of the passed by your lordship.
Then you have to prefer and
My lord, that is the remedy, my lord, but they cannot act as a appeal court, my lord. Kindly come to their order, my lord.
This merit I cannot entertain.
My lord, there is a
You know
double
that.
score of contempt, my lord.
Then you have to prefer and read petition, not in contempt. You can file this contempt if the time they have not followed the time frame. Only this merit.
They have, first of all, they have not maintained the
that
time
be
frame,
the
my
issue
lord.
with the contempt, that can I
They have
understand.
passed the order after the stipulated period fixed by your lordship, my lord.
That would be the matter of contempt, not
Contempt,
the
my lord.
merit.
That is the, this is the first contempt, my lord. They have passed the order after the order stipulated period, my
You
lord.
have to prefer a read petition on that if you want the matter to be hard on merit.
My lord. But in this case, my lord, I was particularly, my lord, if they are appearing, my lord, state authority, let them controverted by their affidavit, my lord, whether I also filed the affidavit in the supplementary affidavit, this challenging this reason order, my
This
lord.
matter cannot be taken in the contempt application, you know.
But
this is not the merit of the contempt. Contempt is very scope is very
that
little.
should be ordered, part should be passed in view of the order passed by your lordship, my lord.
Then you challenge that. You challenge, there is a separate cause of action, you know.
That is separate cause of action,
Then
my
you
lord. But
challenge
your
it.
court's order should be complied with, my lord. But that should not be challenged in the writ, my lord. It is violated in second score, my lord. That cannot be challenged in writ court, my lord.
Yes, it can be challenged. The merit can be challenged in the writ court.
That is the merit of the writ, my lord. But there is another contempt, my lord. They have violated your lordship order. They have.
Yes, you can file the contempt application or press the contempt only for the violation that within time frame they have not passed the order.
But my lord,
only this is the issue.
But my lord, they have controverted your lordship order, my lord.
Oh, that is not the issue.
That cannot
here.
do the authority, my lord. Authority is not the appeal court, my lord.
What are
Kindly,
you,
if your
what
lordship
are you doing? What are you doing, sir? This is
Your
not
lordship-
the contempt application. I will
My
not take up this.
My lord.
I will only take up the contempt application that they have not passed the origin order within the time frame. That would be the only issue in the contempt.
My lord.
Not other matter. What they have passed, what origin order they have passed, that is not issue in the contempt application.
My lord, the authority cannot controvert your lordship's order, my lord.
That
is
is
a matter of appeal, my lord.
altogether separate issue, separate cause of action.
That is separate cause of action.
Then
my
you
lord.
file the separate writ, not the contempt.
My lord, this portion cannot be challenged in the writ, my lord.
Which
They have-
portion?
In second violation of your lordship's order, my lord. The authority acted as an appeal court. It is one time of contempt, my lord, your lordship's order.
No. That cannot be decided in the contempt. What merit is there? What merit is here?
There is a certain direction, my lord, to the concerned authority, my lord.
That can
They
be.
cannot go beyond that, my lord.
No. You are arguing otherwise. I can understand if you are pressed the contempt application only in respect of the time frame.
First of all, they have violated the
Only
time. my lord.
this issue can be taken up in
And
contempt.
thereafter, my lord, they have passed the order in contrary to
Again,
the your
you are-
lordship.
Again, you are arguing on that point. That point cannot be taken up the contempt matter. Contempt matter is very limited. You
I
know the
understand, my
matter.
lord, your
Then
lordship order.
how can I go to the merit of the any order?
But it is on record, my lord, that what they have done, my lord.
That can I take look into another writ, not in the contempt.
As your lordship, please, my lord.
So
I have authority, I have the alternative remedy, my lord, to file
whether
the
you want to
petition.
proceed or I will give you the liberty to file separate application.
If your lordship can
No,
proceed with the writ
only-
petition, my lord, I
only
will
merit-
serve notice, my lord.
Only
Although they
merit
have
is
appeared, my
there
lord.
that the time frame which this court has directed they have not followed. Only this merit in the contempt application can be gone, not the other merit.
Within stipulated period, they have not passed the order.
Only this merit can be considered in the and present contempt. If you want to proceed with the merit of this written order, you have to prefer a separate writ.
My lord.
There is a separate cause of action. So you proceed to file a separate writ.
My lord, as your lordship.
Please take down. Instant contempt application has been preferred by the petitioner for willful and deliberate violation of order of this court dated January 3, 2025, passed in WPA 17478 of 2022. Full stop. Having heard the learned counsel for the petitioner, it appears that by passing the order under contempt, this court directed the concerned state authority to consider the representation of the petitioner or implement necessary space structure and other terms and conditions of service of the petitioner by virtue of memo dated 557 dated 2nd September 2010. No, 2nd September, 2nd October 2010. The date of memo shall be correctly read as 2nd September. 2nd September করেছি? না, 2nd September এটা। 2nd September 2010. It is the contention of the petitioner that though the petitioner has made the representation within 4 weeks from the date of passing of this order, but the concerned authority has passed a so-called region order only on 24th of April 2025. Full stop. He submits that the time as framed by the court was not followed by the authority. Thus, they have deliberately violated the order of this court. He further submits that the concerned authority has entered into the has passed the region order abruptly violating the direction of this court. Abruptly violating the direction of this court. Having heard the learned counsel for the petitioner, it appears that the authority concerned has passed a region order which, in view of the petitioner, is itself violating the order and direction of this court. Full stop. Next para. In contempt jurisdiction, this court cannot deal with the merit of the region order, so-called region order passed by the concerned authority on 24th of April 2025. Rather, the petitioner has a new cause of action to challenge the said order, which is violative the dictum of a court. Full stop. Under the above observation, the petitioner is at liberty. Under observation, the instant contempt application is hereby disposed of with a liberty to the petitioner to take appropriate proceeding, to file appropriate proceeding in respect of the cause of action which arose by passing the region order of the authority dated 24th of April 2025. I make it clear that the petitioner on the said proceeding to be filed against the against the region order dated 24th April 2025, comma, they can demonstrate that the so-called reason order was passed in violation of time frame, in violation of time schedule, as fixed by this court. Under the above position, the instant contempt application is disposed of.
This is my application for vacating of interim order.
This is with regard to the vacancy under 2013 order, my lord. And your lordship knows that the matter is being heard by the division bench.
No, my lord, in my case, vacancy was proceed in terms of the 2024.
2024. No.
I can demonstrate, my lord.
My lordship may recall on
Yes,
this
yes.
matter I was arguing the point of maintainability. Whether this is at all attracting the Article 19(1)(g) of the Indian Constitution or not. I have shown the various judgment. Lordship has posted this matter, and I believe on 28th July, the same kind.
2013.
2013. 13. No, that point is not
matter.
set.
Vacancy notice given effect from 2nd August 2024.
But vacancy was published under 2013 control order, and your lordship, my lord, there is an order not to grant license. Then your lordship, my lord, passed last order. Kindly see the last order.
Last order on 19th August.
Just a moment.
The bol the action
19th
sort of
September.
bol.
That time 13 control order not there.
Control order.
19th August.
Yes, my lord.
My lord, whatever.
18th of September is the order.
19th September 2024.
My lord,
That time 2020 control order not there.
Obviously, the 2013
Vacancy notice was proceed in terms of 2024 control order.
Mr. Thara's contention is that what I have understood, at the time of passing of this order, this 24 order was not in force, not came into the force. That is why he is saying that this has been passed under 2013 order. তাই বলছিস তো?
No.
Oh, possibly he is saying the opposite.
Opposite.
Reverse.
Your lordship, kindly see page 19.
Opposite.
That is a vacancy notice. That notice is under 2013 order.
No. Mr. Sengupta, are you arguing in this matter?
No, Mr. Sen.
Lordship may recall
Not in this matter.
the basic things or pith and substance of the same is to show that cutting of a number of the beneficiary is not affecting the fundamental right of the PS dealer. This is the I was arguing from the very beginning. Now, if you
Whether in this matter or another matter?
this is 2024
No, not in this matter. You are arguing 3 matters on the other.
3 other matters I was. So in that event also, indirectly I have to come up with the same argument, same set of argument. Because if your lordship sees,
I understand.
3-4 things, I would not trouble your lordship 2 things.
Now today is fixed for vacating the interim order.
Correct.
Can 1.
My lord.
Can 1.
And your lordship had earlier directed that it will appear along with the petition for hearing. But in any case, my lord, if my learned friend is agreeable, then I may take time for filing the affidavit in opposition to the vacating application.
Then you place the opposition
My lord.
against can 1.
My lord.
And you raising the point of maintainability.
Naturally, Willard, I am taking the point. Because
now, in this matter, you have taken first time.
I will.
But
on the other matter,
I have argued.
This application was vacating. In this matter,
Pass the interim order, that time state was not there.
This is not a hearing of writ petition.
When your lordship pass the interim
No,
order,
I cannot take
that
the
time
point.
state was not there.
I cannot take the point.
I am also not there.
I understand. I know that.
Time of vacating.
I know that is expertise order. I know that is the issue, not the matter. Okay. Can 1 of 2025. This is an application for vacating of interim order. Vacating of interim order. Filed by respondent number 5. Mr. Agarwal appearing on behalf of the petitioner seeks to use affidavit against the CAN application. Let the affidavit against CAN 1 of 2025 be placed.
Within 3 weeks, my lord.
3 weeks.
My lord.
3 weeks from date. Reply if any by the petitioner within 1 week thereafter. Reply by the respondent number 5 within 1 week thereafter. Let the matter appear in the list on 6th of August 2025 under the same heading. Quantum maintainability as raised by the learned counsel
My lord.
for the state. Learned counsel নামটা লিখে দিন মিস্টার সুমন সেনগুপ্ত।
এখন নয়।
Be kept open.
My lord.
Public prayers. দুটো hearing হবে কেন?
I know 14, I am for the petitioner. Well, your lordship on 21st January 2025 directed to the state respondent to file the report, my lord. Thereafter another date, my lord, on 15th May, your lordship further directed to file the report of the state, my lord, but 26 weeks has been lapsed, my lord, but they did not file the report. My lord, then exception and just
for the
Private.
my lord, state has
Why?
So
Not
today,
exception.
report is filed by the state.
My lord,
Lordship, it
exception to be filed by. My lord,
file an exception.
I will file the exception, my
For
lord.
the delay, but
No, no.
so many cases are there, each and every
Maybe.
thing we have to take in individual instructions, then we have to get it vetted,
Yes. I know it.
and officers have other works also.
Very good. Please take down. Report in the form of affidavit filed on behalf of the state, respondent number 1 to 4, be taken on record. Petitioner has leave to file exception against the report within 2 weeks.
My lord.
What you are the private respondent. You are the appearing for the first time
Yes, first time.
today. Okay. So report perhaps in favor of you.
Yes.
What is the
What he will argue, your lordship. Everything the state has to argue. Baap re baap.
Okay, sir. Okay. The learned counsel for the now the state respondent is to serve the copy of report upon the private respondent who is appearing today. Okay. Let the matter appear in the list under the heading hearing.
Extra copy ache?
Under the heading hearing in the second week of August 2025.
My lord.
Grateful, your lordship.
Lordship, non-proceeding.
The one favorable order for me.
Allegations are not admitted.
No.
Where the allegations are deemed to have been denied.
All the there are 3 writ petitioners.
3 writ petitions.
3 writ petitioners.
Yes.
Please take down. State is represented through learned counsel, Mr. Sengupta.
Lordship, kindly letter should be kept in record.
The instruction should be.
Okay. Yes. Learned counsel on record, learned advocate on record on behalf of the petitioner submits that the petitioners are not intending further to proceed with this matter. He placed the written instruction of the petitioners. Let the written instruction of the petitioners be kept on record. considering the submission of the learned counsel for the learned advocate on record for the petitioner, and also after perusing the written instruction of the petitioners, let the instant writ petition be disposed of as disposed of for non-prosecution. Disposed of for non-prosecution. The any interim order passed by this court during the pendency of the instant writ petition be hereby vacated. Connected applications, if any, are also disposed of.
Allegation of police, but the allegation has been deemed to have been denied. Since no affidavit,
Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not. Call the list.
My lord, I am on behalf of the petitioner praying for only not today. Mr. Molad Dhar is appearing in this matter, my lord. Due to
Not
some-
today. Next.
Time extension change. Lord.
Yes, my lord, in this matter, I am appearing for the petitioner, my lord.
Amrit, 8 hours.
May I place the matter, my lord?
Petition. The other side. Primary is not.
Petitioner. Who? না সন্তোষ কুমার মাতো আছে এর মধ্যে। তারপরে addition of parties.
May I place the matter, my lord?
No, whether a report.
No, your lordship. No, because this was a bulky petition and we have to, it will take some time.
So you have to take on record one application.
Yes,
Yes, ma'am.
your lordship, there
I have filed
addition
application
of
for deleting the
What is the application number? Can?
application number 2, my lord. Can number 2.
Can 2. Where is can 2?
For deleting the response number 10, my lord. Pro forma response.
Who is respondent number 6? You have filed the affidavit.
Is this, my lord?
No, let me find out.
Parenting process.
My lord, I have filed the affidavit in reply against the respondent number 6. You lordship kindly turn to the.
Just wait. Where is your can 2?
Can 2 is application for deleting the pro forma respondent number 10. Late Mohendranath Mahato.
কোথায়? Can কই?
Monindranath Mahato.
Can কোথায়? Can নেই তো রেকর্ড। Can 2?
এটা can 2 আছে আপনার?
হ্যাঁ। এটা একটা সিম্পল ব্যাপার।
তো রিড পুরোটা।
But আমি না নাম্বার নেই, এটাকে can 2 করে নিন।
Can 2.
Can 1. Can 2 running the list আছে।
May I suggest one thing? Send the matter to the district. Is on the Chakwarpur against the
reason order against. Send the matter to the send the matter to the district register by cancel. District controller.
The record, there is no such scan like that.
We have also been served, but that petition is not numbered. On
At least you have a copy of, I don't have.
But it has been listed. It has been listed.
Lord, I have a copy.
Yes.
Give me a copy. বের করুন ওটা কোথায় আছে লিস্ট হচ্ছে মানে থাকবে তো নিশ্চয়ই
দিয়ে দেন আমি দিয়ে দেন
Instructions আছে তুমি যদি বলো
question.
Um,
Yes, tell me about can 2.
Yes, my lord, can to the actually the advocate on the basis of the affidavit affirmed by the late Monindranath, the matter has been drafted by the learned advocate and record, my lord. Your lordship then inadvertently the response number 10, the proof form response number 10 has been added as in the proceedings. Therefore, I have filed the affidavit when come to the knowledge thereafter, immediately thereafter, in this honorable court. Then your lordship directed to file the deleting application, and then I have filed the deleting application.
What is
Last-
the name of respondent number 10?
Respondent number 10 is Monindranath Mahato. It should be deleted. The pro forma respondent, the uncle of
So
the.
where is the death certificate?
I have annexed it
You have
with
annexed
the earlier affidavit.
can 1,
Yes, my lord. Paragraph page 17
page 17 of what?
of this application. Annexure P8. Page 17.
This relates to subject to correction supplementary affidavit on behalf of the retributor. That is not in the can.
No, death certificate at page 17.
Yes, my lord.
Monindranath Mahato.
Yes, my lord. The uncle of the petitioner. Inadvertently, it has been made the party as a pro forma respondent. He made the affidavit. So, your lordship
No, they have
Last
got
two
the
petition you have
information
directed-
from your supplementary.
directed to file the deleting application. I have filed the deleting application.
Very good. Yes. Pratik.
So far as deletion of name, my lord, I cannot stand it up.
Okay. Please take down can 2 of 2025.
My lord, I am suggesting one thing, my lord. This matter has come up before your lordship by challenging the reason order 4 times. And reason order passed by the subdivisional controller, food and supplies. And I have again filed and challenging the reason order. Then your lordship passed the 2 orders by admitting the, and I filed the affidavit in reply. Filed by the my well-known friend.
They are the answering respondent. The state is the answering respondent. What they shall do, that is their issue.
I am suggesting on behalf of myself, your lordship directed to the district controller to consider my representation by cancelling the reason order.
Why?
And
If you want to cancellation of the order,
I shall fight.
You should fight.
no, let them
Then can you
file
file
the
the-
affidavit.
You file the exception.
আমাকে এক মিনিট বলতে দিন lordship if lordship directs I will argue on the basis of instructions that I have received. If this is a very simple case, your lordship, if FPS of Mohanlal Mehto was tagged with nearest FPS dealer Prashanta Kumar Mandal, Jhanla 1, block for uninterrupted supply of ration commodities of the beneficiaries. SCFNS Jhalda issued a hearing notice on 21/1/2022 and asked him to remain present during hearing. At the time of hearing, other legal heirs of late Mohanlal Mehta.
Whether you are ready to proceed on the basis of the report?
Yes, my lord. If my learned friend file the report, then I have no question. If
Very
not filed, I should proceed in accordance with law. Then your lordship come to the affidavit in reply.
No,
I have-
forget about it, forget about it. Are you ready to proceed with the report or you want the file affidavit?
What? Again, I shall file the affidavit. I shall file the affidavit.
That's why I'm asking.
I am, my lord. I am.
So affidavit is required, so that you can challenge by filing exception.
Yes.
I was ready to argue
Then of this.
the set of
Is
instructions that I have
today ready to file the?
I am ready to file the affidavit.
No, you have to file a affidavit then.
Yes, my lord.
If you are not accepting their.
Yes.
Okay, please take down. Let me dispose of the can two.
Not the exception, exception to that.
Let them file that.
Last occasion, your lordship also directed.
Respondent number 6 filed the affidavit. I have filed the reply.
Recorded, my lord, that I have.
That is already there. They are
Yes.
seeking some time to file a report.
Yes.
File a affidavit.
Yes.
My lord, I have
very
copy of the.
simple point.
Let
of
them
law is
file.
involved.
Let them file ready, get
Yes,
ready
madam.
first. Can 2 of 2025, this is an application for deleting the
So
name
that's the
of proponent respondent number 10,
আপনারা আমার
namely
কাজটাকে
let
বাড়াতে
Monindranath Mahato,
ওখানে যখন ফাইল
heard the learned counsels for the petitioner, peruse the death certificate of deceased respondent, proponent respondent number 10.
the signature of
Respondent number 10, proponent respondent number, হ্যাঁ, respondent number 10 বলেছি তো, 4 বলেছি,
affidavit আছে
4 বলেছি, আচ্ছা, respondent number 10, let Monindranath Mahato, এই বলেছি তো,
এটা
respondent for the state respondent as well as the private respondent number 6, there is no objection. Considering the same, the application being can 2 of 2025, we considered and disposed of, full stop, the name of pro forma respondent number 10, namely let Monindranath Mahato be deleted from the cause title of the writ petition, full stop. The petitioner is to correct the cause title as per cause title within a week from date, full stop. Next para korun. The learned counsel appearing on behalf of the state respondent extension of time for filing report in the form of affidavit against the writ petition. Let the report be filed within 2 weeks.
Mr. Chatterjee.
2 weeks.
2 weeks.
Let the time for filing report be extended till 2 weeks from that. Let the date of report, let the filing of report, let the date of filing of report be extended for a period of 2 weeks from date. On such, the parties, the petitioner shall file exception stroke reply against such report within 2 weeks thereafter. Let the matter appear in the list in the second week of August 2020.
Kindly fix the date. Kindly fix the date as because kindly accommodate myself. I am partly practicing in the Supreme Court. Therefore, 14th from 14th Supreme Court will be open. Therefore,
12th of August.
I'm grateful to us.
12th of August.
Grateful.
12th.
You also want to say, okay, the state respondent shall supply the copy of report upon all the parties.
I'm grateful to us.
Can to disposed of.
Hello. কেউ এত লজ্জা পাওয়ার কি আছে?
Time to leave. Yes.
18, your lordship, I am for the petitioner. I am praying 1 week time to take instruction because state has filed one affidavit, one report, your lordship. So
Let them, not this week, not this week.
grateful.
So we have already filed the report.
Yes. They have
Report is there.
Yes, on report. Only report, not through affidavit.
No, no.
Only report.
Yes, take a note of the report.
Great.
Not this week, next.
Thank you. As per direction of your lordships, on the earlier occasion, I have already filed one supplementary affidavit annexing all relevant documents in contentions of my case, lordship. And I have also served upon the state and the private respondent also.
Mr. Arjun Rai Mukherjee is appearing in this matter. What is he?
He was here just now.
Sri Chaudhuri and Arjun Rai Mukherjee. I am passing it over. You just inform Mr. Chaudhuri. Mr. Mukherjee, okay? Pass over for a while. Pass over code. Next. You have that picture, chapter. For that, Nada code.
I am for the so far WP number 13773 of 2019. I am for the petitioner.
Vishwanath Mukherjee and Buddhadev Mukherjee.
Yes, my lord.
I am for the Buddhadev Mukherjee.
Vishwanath Mukherjee, my lord, private petitioner's conspiracy.
Today,
Today the argument,
Mr.
my lord.
Chatterjee is supposed to argue
Yes, my lord.
on reply.
So far, Buddhadev, that has been concluded. And so far,
Vishwanath Mukherjee's reply.
Yes, my lord.
I will also
Vishwanath Mukherjee is concerned. Vishwanath. The mother of the petitioners, my lord, died on 5th December 2014, my lord. My lord is expired on 28th December 2006, my lord, leaving behind his 3 sons and 1 daughter, my lord.
Yes.
My lord, Rabindranath Mukherjee, the first son, and second son is Subhas
Mother
Mukherjee.
of the petitioner is the erstwhile MR dealer.
Fine. The mother.
Mother. Yes.
Mother of the petitioners. Gauri Rani Mukherjee is
Yes.
died on 28 December 2006. Left behind 3 sons and 1 married daughters, namely Robindranath Mukherjee, the first son, second son, my lord Subhas Mukherjee, and third son, is Vishwanath Mukherjee, and my lord Sondha Banerjee is the married daughters.
Do you have used the affidavit?
Yes, my lord. Affidavit in opposition, my lord, filed by the respondent number 5, my lord. That was affirmed on, my lord. Pursuant to the my lord's direction, reaffirmed on 19th February 2024, my lord. February 2024, my lord. That was affirmed, my lord. Reaffirmed, my lord. Initially, that was affirmed, and pursuant to the my lord's direction, that was reaffirmed on 19th February 2024.
Yes. Proceed.
3 sons and 1 daughters, my lord. Leaving behind is after death of my lord Gauri Rani Mukherjee. He died on 28 December 2006, my lord. And in the meantime, my lord, Reba Mukherjee, my lord, filed 1 application before the subdivisional controllers regarding, my lord, prayer for the compensate appointment.
Who filed first? Rabindranath Mukherjee.
My lord, Reba Mukherjee.
Reba Mukherjee. Reba Mukherjee. Who is Reba Mukherjee? Married daughter.
Daughter-in-law.
Daughter-in-law, my lord.
Daughter-in-law.
Jointly application has been submitted.
My lord, page 24 of the writ petitions, that was rejected, and after the rejection of the orders, 1 writ petition has been filed by Reba Mukherjee before Honorable Justice.
3 জনে ফাইল করেছে।
Reba Mukherjee নাম আছে।
এই তো page 22 cost item.
There's a rejection of the order. Page 24, my lord, there's an order of Honorable Justice Aniruddha Bose, my lord. Page 24 of the writ petition, my lord.
So first Reba Mukherjee was denied.
I'm placing the order of the 5th December 2014, my lord. That is the first litigation, my lord, the first one, my lord. On the date of the original dealer, applicant was made by her daughter-in-law and 2 grandsons jointly, my lord. Those type of the compensate appointment, my lord, finally the lordship was Honorable Justice Aniruddha Bose was pleased to direct consider this matter on the basis of the 2003 control orders, not 2013 control orders.
Yes.
My page, my lord, 26 of this orders. In this case, daughter-in-law of the grandsons do not come within the list of the relations specific at the point of time, my lord. Daughter-in-law and the grandsons in the come under the purview of the family, my lord. Subsequently, that was amended, and my lord, the rightly rejected. I do not find any law in the said order of rejection considering the provision of 2003 control orders and the above referred circular, but I am also in view that considering the fact that the vacancy arose in the year 2006 when the sons of the petitioner sought to relinquish the right of the accommodate the grandsons or the daughter-in-law of the deceased dealers for the purpose of obtaining license of dealership, another chance may be given to the specified legal heirs of the deceased dealers of being appointed as a dealer for the subject vacancy on compassionate ground. Their decisions not to take their claim on being appointed as a dealer was on the undertaking that daughter-in-law or the grandsons of the deceased dealer would be eligible for appointment, since the later category of persons are ineligible for being appointed as dealer. In my opinion, the persons who otherwise would have been eligible, my lord, kindly, otherwise would be eligible for being appointed as a dealer should be given another chance to take their claim. for the purpose of the application shall be made afresh by any of the sons or other specified relatives of the deceased dealers, and such application shall be considered to be in continuation with the earlier application made in the regard. Such application shall be made within a period of 3 weeks, my lord. Subject to the fulfillment of the other eligible criteria, an application shall be considered and decided upon within a period of 6 weeks from the date filing thereof by the concerned authority. That the applicant will have to file an application. So that's the order of the my lord Court Justice Basu, and it is on, my lord, 5th December 2014, my lord. And
Yes.
after that, my lord, and consequently, date of the mother of petitioners, grandson, and grandlords or decide and applications for the fair price of land on compensatory ground on the basis of the family settlement, the respondent refused to consider the prayer of the same and rejected, challenging the said rejections. A writ petition, my lord, another writ petition was being number, my lord, 12369 of 2014 has been filed before the Honorable Court, and my lord, page 28, my lord.
Page 28.
28, my lord. There's another orders, my lord.
Writ petition 8736.
Yes, my lord. Page 28 on the writ petitions.
Who filed this? Subhas Mukherjee.
Subhas Mukherjee, another son, my lord.
Another son.
The subject matter of the dispute relates to filing of the vacancy of fair price of dealership on account of date of the original licensee, Gauri Rani Mukherjee, on 28 December 2006 by Solomon order dated 5th December 2014 in writ petition 12361/2014. Honorable single bench was pleased to direct that filing of the vacancy of the question of the respondent authority out to be guided by existing control order of 2003 and not by the control order 2013. See, Mr. C. Sahara takes this quote on the page 20 of the writ petitions, being the order impugned passed by the subdivisional controller, rejected the application of the petitioner on the state of the control order 2013. The short submission, Mr. Sahara, is that having regard to the order dated 5th December 2014, it has been made clear that the decisions must be taken under the control order 2003 and not under the control order 2013. My lord, such and such, my lord, the subdivisional controller 2024 program, respondent shall consider the claim of the petitioner afresh strictly in accordance with law, order dated 5th December 2014. My lord, after that, my lord, page 13, my lord, the application, my lord. The petitioner made an application, Vishwanath Mukherjee made an application, form of the application on the dealership, my lord, page 30, my lord.
When the application was filed?
Application was filed, my lord, on 6th July 2021, my lord.
Vishwanath,
my lord.
6th July?
6th July 2021.
21,
my lord. And my lord, the order was passed on 5th December 2014. And there is no explanation why he is kept silent over these matters, and his application was made on.
That means Justice Bose.
Bose, my lord.
Bose's order 2014.
14, my lord. 5th December 2014. There's an rider is there, my justice was pleased to direct that whoever come under consideration, they can apply. On the basis of this, my lord, the petitioner applied on 6th July 2021.
Yes.
And at the point of time, my lord, perhaps, my lord, 2013 control orders come in the force, my lord. And my lord, the form C is application. My lord, peruse the form C in application page 30 of the writ petitions.
Form C.
Form C, my lord. Kindly see, my lord. Take a travel, my lord. Form C of the application of dealership.
WPDS 2013.
2013. He applied on the basis of 2013 control orders. And there is my annexures with the relevant documents is there, the no medical the declarations. Page 37. I, Vishwanath Mukherjee, son of late Gosto Bihari Mukherjee, residing village such and such, have applied for the FPS dealership on compassionate ground. I do hereby declare that in compliance of GO 1707 dated 21st July 2014, I shall upgrade the size of my godown 400 square feet along with the covered space 200 square feet adjacent to the godown used on office purposes. APS automations. The godown will be ventilated Pakka structures and I shall be built and such. And my lord, the Form C of the West Bengal PTA's Maintenance Control Order 2013. He giving the declaration.
You are reading page
37, my lord. Page
37
declaration, my lord.
Vishwanath
The
Mukherjee.
middle portion, my lord. I am emphasizing he's well aware that is applied on basis of the 2013 control orders because his application was on
Form C.
Form C, my lord, and that is on
2013 control order.
6 July 2021. And he is well aware that his application is on the basis of the 2013 control orders. I shall also be, my lord, in consonance of the with points Form C, West Bengal PDS Maintenance Control Order 2013. Such upgraded shall be undertaken within 6 months. Failing which appropriate action will be taken. My lord, he is well aware that his application will be considered on the basis of 2013 control orders, and he applies on the basis of the Form C, my lord. And on the basis of this, my lord, he is given the affidavits. So no objection affidavits is there. Page 41, my lord. I, Vishwanath Mukherjee, late Gosto Bihari Mukherjee, age 65 years and religions Hindus by occupations, pension holder, my lord. At the point of time, my lord, when he apply by occupation, my lord, he is saying the pension holder. Residing as such and such, do hereby solemnly affirm or declares that I am the citizen of India. I have made application for the license of a dealer on compassionate ground on the date of Gaurirani Mukherjee, that I reside with the family of the deceased or incapacitated license, and I undertake that my earning from the dealers will be a source of support from myself and the other members of the family. That I am presently retired from the service, Allahabad Bank, Dom branch, that my occupation is pension holders. There is an admitted position at the point of application. At the time of application, he is a retired employee, retired bank employee, and getting pensions from the bank. And after getting application, my lord, department sought some clarifications, my lord. Page 44, my lord.
Yes.
Vishwanath Mukherjee requiring information about past service of amount of pension presently received. With reference to the subject captioned above, we are hereby requested to provide the information about past service or amount of pension presently received by you, without which is not possible to move the next course of actions in the process of engagement of you and APS dealers on compassionate ground in place of your mother, late Gaurirani Mukherjee, ex-dealer under SCFS, Bonga, and we are requested to provide legal heirship certificate in case of records issued by the competent authority in respect of ex-dealers. Well, that is on 13 December 2021.
Yes.
And on after receiving these letters, he replied this: in pursuance of the letters dated under reference, I regard submission the original legal heir certificate. When he supplied the legal heir certificate, and I have also submitted before you under the earlier letters. However, in desired review, I again submitted the original legal heir certificate. And my lord, the next page 46, submission of pension certificate. That was on behalf of the my lord bank branch manager, Dom branch, Allahabad Bank, my lord. It is being to your kind notice that Sri Vishwanath Mukherjee, son of late Gosto Bihari Mukherjee, address such and such retired staff, our esteemed bank, who joined United Bank of India, Allahabad Bank, 2nd November 1978. And my lord, he retired on 31st August 2016 from the Allahabad Bank.
Yes.
And he's getting pension of rupees 24,700 approximately. He is getting pension, my lord, 24,700 approximately. And the next page in the hearsay certificate, the last page, point 49, my lord, the rejection of the prayer of Vishwanath Mukherjee with reference to the above, page 49, my lord.
Yes.
With reference to the above, this is to inform you that the director of GDPS has rejected the prayer of Sri Vishwanath Mukherjee for engagement of FPS dealers on compassionate ground in place of his deceased mother, late Gauri Rani Mukherjee, as the applicant is a retired employee of Allahabad Bank and has been receiving monthly pension, which is enough to regular means of subsistence. My lord, in clause 26 of the control order, clause 26 minus in control order 2013 control orders has clearly emphasized that the whoever come in the zone of consideration compassionate count, they have to fulfill certain criteria. And in this case, my lord, the petitioners is getting 24,000 rupees as a pension, my lord. And
Having
he is in
regular means of subsistence.
regular means of subsistence, my lord. I am, my lord, relied on clause 26 engagement of compassionate ground in a case of death or in a case of incapacitation on medical grounds subject to the satisfaction of the authority of any existing dealers, pair of any family members of the deceased incapacitated dealers having no regular means of income may be considered on compassionate ground if such pair along with the formal application and Form C2 along with the Annexure 1 with the requisite fees and prescribed in Schedule 1 corroborative documents as per the checklist of no objections. And there is a record of no objections. And there is an admitted position, my lord. He is getting the pensions, and that is getting from 2006 to after his retirement, my lord. And my lord, it is not a position that his family members, his families is a financial crisis, and that is in my report, my lord, is specifically mentioned that Rabindranath Mukherjee first son is an established businessman, and he is along with son Sri Sandipan Mukherjee's grandson run a fair price shop, my lord, foreign liquor shop, Bonga, my lord. Sri Subhas Mukherjee's second son is an employee of the government employment, holding a dignified post in the service, and he's an only son, Subhas Mukherjee. Sri Buddhadev Mukherjee, grandson is in the MBA, and Sri Vishwanath Mukherjee, third son, is a bank employee. He is a nationalized bank and Thakurnagar branch, who is the husband of Srimati Reba Mukherjee. My lord, it is specifically mentioned in my report that he is getting pension, and that is, and other family members is not dependent on the income of the fair price of, my lord. And regarding, my lord, principal on compassionate government, the applicant some arm of the account of compassionate appointment, it is provided an opportunity to the family, my lord, the emergent financial crisis and overcome the emergent financial crisis. And my lord, in this case, my lord, it is not a position that his family is in extreme emergency crisis, because all the members of the family members are they're the independent income, my lord. They are not the separate income, that they are the dependence on the income of the FPS license, my lord, at the point of time, my lord. Because they are the independent source of income, my lord. So far my report is concerned, the first one is in my lord, foreign liquor source. The second one is the government employment, my lord, and third is in some separate business, and he is a retired person, my lord.
So this is only argument of the petitioner that 2003
Control order is
has
governed
to
by
be
2000
considered,
not 2013 control order. My lord, I am.
You have considered 2013 control order.
My lord,
That is not
if I assuming that he is governed under 2013, 2003 control orders, but that is, there's a clause is there, my lord. He is an independent income. My lord, compensate appointment is not an hereditary one, my lord. It is not a right, my lord. If someone is independent family incomes, he is able to subsist on the families, my lord, he is not come under the consideration of a compensate appointment, my lord. And my lord, in the basis on this field, my lord, I relied on judgment, my lord. Honorable Division Bench, my lord. That was considered by the Division Bench. In this case, my lord, the petitioner is also army personnel and is getting the family. My lord, this case, my lord, he's the army personnel. He is getting pension quantum of 13,000, my lord. And in this case, my lord, Division Bench interferes and stay the operation of there's a direction of the single bench that will consider as an FPS dealership, and that was stayed, my lord, Justice Justice Mantha and Justice Ajay Kumar Gupta, my lord.
Yes.
And this copy is there, my lord. It is admitted position that writ petition respondent was drawing pension as a rate of 13,000 per month under National Pension System (NPS) and payable in retired armed force personnel, which is regulated by the Pension Fund Regulatory and Development Authority, Clause 26. Though, my lord, is relied on Clause 26, one ratio, the compensate appointment, my lord. It is clear explicit from the plain reading, the Clause 26, that the writ petition respondent was barred from the applying on the compassionate transfer of the APS license of his father for having a clear monthly source of income. The ratio was that he is enough sufficient monthly income for their survival, my lord. And my lord, on the basis of this single bench is the opinion that court has committed an error in this on this score, even if found by a court of law that another armed force person was, there's a negative equity cannot claim, my lord, another person was given granted, that was turned down by this court. The principle against seeking negative equality would come in play of these facts. For this reason stated herein, the court is inclined to stay the operation of the judgment dated 29th August 2003 until disposal of the appeal. Accordingly, can 2 is allowed and disposed of. There are some directions. But ratio was taken by this that when someone is sufficient means of subsistence, my lord, he cannot claim his right as a compensate appointment under the clause of, if I am assuming that he is in come under zone of consideration of 2003 control orders. If he, my lord, considers the 2013 3 control orders, my lord, but he is in sufficient means for subsistence, my lord.
Now, whether 3003 control order says about the sufficient means of subsistence, this is argued.
My lord,
this is argued that 2013 3 control order does not say about the requirement of sufficient means of subsistence like that.
What is the main principal ratio of the compensate appointment is, my lord, the survival of the family, my lord. That is taken care of. It is not a regular appointment, my lord, and it is not a hereditary appointment, my lord. It is not a right. Right was created by the statute, my lord, and that is specifically on the bindings of the case to case, my lord. That is varies on the case to case, my lord, because their family is an independent source of income.
Yes.
And he is also getting pension, my lord. And it is not then in this case, my lord, 13,000 was considered. There's a meager amount was considered. In this case, my lord, he is getting 24,000 at the point of time. At present, he is getting much more. And my lord, this is considered by the this question, my lord, these laws are kindly considered, my lord, that if is enough sufficient means of subsistence, that is considered by the my lord regarding the compensate appointment, my lord. And my lord, in the application format, my lord, I'm saying page 13, he's applied on the basis of 2013 control order, the application form, page 30, my lord. From C, my lord, he's well aware that he's applied on 2021. At the point of time, my lord, 2013 control order in force. Though, my lord, is relying the judgment of Justice Basu, my lord, 5th December 2014, my lord. But when he applied on, my lord, though, my lord, on the basis of the judgment, his liberty was given within a period of 3 weeks, my lord. On the judgment, page 26, my lord, 5th December 2014, my lord. Earlier application made in regard such application shall be made within period of 3 weeks, my lord. And he applied on 21st July 2021, much later, my lord. And he applied on the format on 2013 control orders. The Form C with the requisite formalities as mentioned in 2013 control orders. My lord, he is not at all entitled to get the benefit because he is not on the under zone of consideration because of the clause 26, my lord. Is my respectful submission, my lord. And my lord, in second one, he is a regular means of subsistence. He is getting 24,700, and that is enough for his subsistence and his family members. It is not that he is an only earning members. Their families is consisting of the 3 brothers, and they are the independent source of income, my lord. And one of the independent business income. It is not at all that, my lord, only the source of income is the FPS dealership license, my lord. For this regard, my lord will not consider, and my lord will not interfere the decision on our director of license, my lord. That's all.
That's all?
My lord, that's all.
This matter is in respect of Vishwanath Mukherjee. So reply by the Vishwanath Mukherjee first.
Thereafter,
Your reply.
so far my reply is concerned, that has been concluded.
Yes, that was concluded, I think.
So for this matter is concerned, I have to give reply to the submission of, since I have a made party.
Okay, you are also party here.
I am also party. I have a
Okay,
made
okay,
party.
okay. So your argument is required to go. Yes, what is your respondent number?
Just a second, madam, whether I have been made party or not. No, madam, I have not been made party.
So you are not party in this matter?
No, I have not paid.
I understand. However, there are 2 writ petitions. Vishwanath and Buddhadev.
Yes.
Now, Buddhadev petition filed, it was earlier. Now, by an order of a coordinate bench, that Buddhadev wanted to tag his matter along with Vishwanath. So that both matters are hard analogous on the same cause of action. Now, so far as Buddhadev is concerned, my landed junior brother my lord has already submitted, in respect of which state has also given his reply. Now, then, my lord, on next turn for Vishwanath, I, my lord, made my submissions in respect of Buddhadev as also against the state. Now, my lord, my turn to reply. But before that, possibly, my lord, he wants to say, since I have also dealt with Buddhadev,
yes,
so he wants to deal with him. Well, let him do this. After that, I will give my reply. Right, sir?
Yes.
So whether my learned senior friend's client
Can to get the license or not. First of all, he has relinquished his
Take the mic.
But he has relinquished his right when the first writ petition was moved. That was moved by the Buddhadev Mukherjee and other 2 persons, not by my learned senior friend's client. You will also kindly come to the cause title first.
Page?
It starts from, my lord, page 20.
Of this writ petition?
Of this writ petition. So kindly come to the page 22. Who are the petitioners? Reba Mukherjee, Sunandan Mukherjee and Buddhadev Mukherjee. These are the 3 writ petitioners.
Yes.
And Buddhadev Mukherjee is the one of the petitioner in another writ petition. Since may I tell this? Initially, the license was granted in favor of one, that the grandmother of the petition number 3. That is, just a second, I am giving the name.
Purirani
Purirani Mukherjee. Purirani Mukherjee.
Purirani Mukherjee is the mother of Vishwanath.
Purirani Mukherjee. Initially, jointly application was submitted by the Reba Mukherjee, Sunandan Mukherjee and Buddhadev Mukherjee.
Yes.
That was rejected. Challenging the same, we preferred the writ petition. That is page 24. The order passed by this honorable court.
May your lordship kindly come to the order passed by this honorable court, page 24. It is dated 5th December 2014.
Yes.
What was the order? I'm just coming to the operative portion, page 26. For this purpose, an application shall be made if afresh by one of the sons or
By any of the sons
or by
other
any
specified
of the
relative.
sons or other specified relative of the deceased dealer, and such application shall be considered to be continuation with the earlier application made in that regard.
Yes.
Such application shall be made within a period of 3 weeks. Subject to fulfillment of the eligibility criteria, the application shall be considered and decided upon within a period of 6 weeks from the date of filing thereof by the concerned authority. The applicant will have to file the application with consent of other legal heirs and shall be afforded opportunity of hearing before final decision is taken in this regard by the authorities. But this court's order is very specific. Any of the son or the specified legal heirs will submit their application. Pursuant to that, father of the Buddhadev Mukherjee submitted his application. That is the, you also will get that thing from my writ petition. My landed senior friend's client relinquished his right by not submitting any application. Now today he cannot say that I have a right to make an application after retirement from the service. You also will get it page 52
of your
from my writ petition.
অন্য একটা রেট দিন তো দুটো রিট আছে আসলে
Okay, sir.
আরেকটা দিন
Page 36, you will also kindly come to page 36. 36, তারপরে 50. Page 36, you will also kindly come to page 36. That is the application submitted by the deceased father of the petitioner, Subhash Mukherjee. I will also got it, my lord. Page 36, P5. 36. May I read, my lord, the application, what has been stated? By the order of the Honorable Justice Aniruddha Bose of the Calcutta High Court, as his lordship then was, by case number such and such, being the legal heir of late Godown Mukherjee, I am applying for the license. The all necessary documents is attached as per in-proposal list.
Yes.
Now you will also can come to next page, page 37. This is the application. It is dated 23rd of February 2015 in terms of the court's order within time.
Yes.
Now you will also can come to page 39 of this said writ petition. What is the affidavit submitted by my landed senior friend's client? That is Vishwanath Mukherjee. He has relinquished his right. I, Vishwanath Mukherjee, son of late Gosto Bihari Mukherjee, aged about 58 years by religion Hindu, by occupation service. Have you also got it, my lord?
Yes.
Residing at such and such, I am the citizen of that's Subhash Mukherjee, late son of late Gosto Bihari Mukherjee, is known to me since he belongs to the same family. I have got no objection if he is engaged as a PhD distributor in place of the deceased Godown Mukherjee, and if the license is issued in his favor to run the distributor. That if any objection is raised by me in future about furnishing the objection, that will not stand valid in the eye of law. There are other affidavits also. Ultimately, my lord, prayer of the Subhash Mukherjee was rejected. Relying Control Order 2013. page 43.
Yes.
Page 43. Challenging the same, I filed another writ petition. That is page, my lord, 28 of the subsequent writ petition. You'll also kindly see the cause title Subhash Mukherjee versus State of West Bengal.
Yes.
In that writ petition, this honorable court was pleased to hold. You'll also kindly see the order. Page 28, it's continued. Page, your lordship, kindly come to page 29. In the light of the above noted fact, this court finds that having regard to the solemn order of the honorable court dated 5th December 2014, the order impugned dated 1st April 2000 is not legally sustainable. The same is therefore set aside. The subdivision contra FNS Bongao 24 being the respondent shall consider the claim of the petitioner only restricted to the petitioner only, not in favor of my landed senior friend's client. Afresh, strictly in accordance with the order 5th December 2014. The 5th December order is that to consider the application under 2003 contract in respect of the petitioner. They have relinquished his right. Now, that has been ultimately now you'll see that prayer has also been rejected.
Yes.
While the said Subhash Mukherjee challenged the said order, he died. Thereafter, petitioner, that is
Yes.
Buddhadev Mukherjee, submitted his application.
Where is the rejection order?
So far, Buddhadev Mukherjee is concerned.
So far as not Buddhadev, Subhash. Subhash's rejection.
You will also page 51 of my writ petition. Since no one NOC was not submitted by the eldest son, that is Rabindranath Mukherjee, prayer has been rejected. Page 51, dated 28th August 2015.
Okay. Subhash Mukherjee.
Yes, ma'am.
So Subhash Mukherjee has challenged this order.
I have Subhash Mukherjee, no. While he was of the challenge, he is to challenge this order, he died.
Okay.
He died on 27th September 2015. An order was passed on 28th August 2015.
Okay. Now we are out of time. 2 PM কিছু আছে কি? 2 PM কোনো ফিক্স আছে কিছু? এখন ছেলে এসে অ্যাপ্লাই করে। একটা ফিক্স আছে কোনটা? ডেট আছে? So I have a 2 PM matter. Thereafter, I will take up this.
I have already a matter.
No, I have also a 2 PM fixed matter. After this, I will take up this matter.
Say that if Lordship takes up this matter and if I could not come, then already will not kindly accommodate me with the short possible. I will come and conclude myself.
Okay. রাখুন। 2 p.m.
My lord, may I have your kind leave to mention one appellate side matter, my lord. Morning, I was late by few minutes, my lord.
Very good.
My
Then
lord,
then come on Wednesday. If you are late, then come on Wednesday. What
My
is the issue?
My lord, the petitioner is a widow, daughter-in-law of the deceased MR dealer. Her application was rejected due to non-submission of all NOC. But our Supreme Court, but this court division bench has decided the issue that NOC is required only from the dependent persons. The person who have not given, they are not dependent, my lord. So the issue will not take much time to decide, my lord. My lord.
Have you filed any writ application?
Yes, my lord.
So what you want?
Now it was listed, my lord, but it is in today's cause list 184, my lord.
Under heading?
Under heading hearing, my lord. Final hearing.
Hearing matter?
Hearing matter, my lord.
So you want what you want?
Upgradation, my lord.
Upgradation?
My lord.
You come Wednesday.
My lord.
I will
Okay.
upgrade.
Okay. Okay. Obliged.
My lordship, I am for the petitioner.
Yes.
Actually, your lordship, we are not aware about this supplementary list. Kindly make it not today and please keep the matter tomorrow.
Tomorrow 2 p.m. I cannot fix. 2 p.m. I have other matters. This is the difficulty. I can urgent today, but cannot fix tomorrow. Give me the diary.
Day after tomorrow.
কি বার? 8 তারিখ কি বার? আজকে তো 7 তারিখ। 7th of July. 2 p.m. 2 p.m. কিছু আছে? তাহলে not today করে রাখুন। Tomorrow 2 p.m. Call the running matter. Signature. Yes, running matter.
I am for the, I was continuing. But since they said Vishwanath Mukherjee, and my submission, Your Lordship, since the Vishwanath Mukherjee has relinquished his right in the year 2000, after the order passed by this honorable court on
Yes.
5th December 2015, he has no right to file an application, that too after his retirement. Number one. Number two, my lord. While this application was submitted by the Subhash Mukherjee, he has given his NOC in favor of the said Subhash Mukherjee. Now the submission has been advanced by my learned senior friend that his application should be considered under the 2003 control order instead of
2003 control.
Instead of 2013 control order. Had the prayer be so, but he would not have made the application under 2013 control order. He has himself made the application under 2013 control order. Page 30.
Yes.
Now you'll also kindly page 30. Now kindly see page 32. what is his declaration in the application itself. That too after the lapse of, my lord, 15, 16, 17, 18, 19, 20, 20, 7 years. Now, sir, kind of page 32.
Yes.
I do hereby declare that the above information is true to the best of my knowledge, and behalf I further declare that I shall abide by the provision of the West Bengal Public Distribution System Maintenance Contract 2013. That is his declaration in the application. Now, your lordship, kindly come to page 36. Is another declaration. Will fulfill the government order 21st July 2014. So far, keeping rupees 5 lakhs in the bank account and the size of the Godown. That is page 36. Next page also. That is with regard to the Form C. In nowhere he has mentioned, even he has not mentioned that in continuation to that application, I am submitting my application. He always said he is making the application a fresh applicant. That too after lapse of 7 years. He is an ineligible candidate. His application should be dismissed. And so far other concerns, whether he has means of subsistence, he is a retired employee from the State Bank of India. He has sufficient means of subsistence. Allahabad Bank, I'm sorry. And he himself said there is a retired person, page 31. Present profession, retired person. He is getting the pension. In the affidavit itself, he has also said the same thing. And so far petitioner is concerned is that, and I have already submitted my case, that I have stepped into the shoe of my father, and it's a clarificated that should be given retrospective effect. Son of
Your
a
merit is 2013 control order is considered, not 3.
So far Buddhadev is concerned, Vishwanath Mukherjee is concerned, and so far I am concerned, I have been considered under 2003 control order. They said I am not coming within the zone of consideration since is a grandson. That has subsequently been amended. I say that if it is a clarification, that should be given retrospective effect.
Yes.
That is my submission. This is my submission. His application should be dismissed, man. My application should be allowed. He cannot be considered under 2003 control order. And that too, retired person. And delay of 7 years.
Very good. Okay. Where is Vishwanath Mukherjee? I cannot hear you. Sorry. Very well, pass it over from your plan. রাখুন এটা। Call next matter.
And for the petitioner, my lord, not this week. I'm paying for not this week, ma'am.
আচ্ছা এইটা আগেরটা রাখুন। Yes, what are you submitting?
Not this week, my lord.
Not this week?
Not this week.
Very well. Not this week. Next.
Last question state a director to file report.
Take the mic. I cannot hear it.
And for the petitioner, my lord.
Yes.
And the last question was state a director to file a report, my lord.
Have you received a copy of report?
No, my lord.
Not received. Who is appearing? Devopriyo Chatterjee, Nilotpal Chatterjee.
My lord,
My lord, in this matter, I am appearing for state, my lord. The report has been. Where is the report? My lord, report subject to correction, my lord. Report has been filed on the earlier occasion, but affidavit direction was passed to file report in the form of affidavit. Yes. Where is the affidavit? So, my lord, I am praying for an accommodation for 7 days, extension for 7 days. I will file the report in the form of an affidavit. Peremptorily within 7 days. My lord. Next week. Not this week. Come on next week. Next.
Lordship, item number 19, your Lordship passed over. that.
Yes, passover matter.
Honorable division bench, my lord. That is why
Very good.
I could not.
Are you ready today? Call the passover matter. Item number
19.
19. Yes.
There was a direction, my lord, to file a report, my lord, in the form of affidavit. Now, on the last day, my lord, my learned friend, my lord, filed a supplementary affidavit enclosing, my lord, several documents. Now, my lord, I have to, my lord, again, my lord, change the entire report, my lord. I have to deal with this supplementary affidavit, my lord. Kindly give me 10 days time, my lord. In the meantime, I shall file. My lord. My lord, there was one supplementary affidavit was filed, my lord. 3055.
Passover matter. এখানটা বন্ধ করুন তো।
On 14th May 2025, my lord, my learned friend filed a supplementary affidavit. This was affirmed on 8th April 2025.
Yes. Please take down. Mr. Arjun Rai Mukherjee, learned counsel appearing on behalf of the state, submits that the petitioner has served the copy of affidavit, copy of supplementary affidavit, for which the state authority has to file a report in the form of affidavit. He seeks some accommodation. Concerning the same, time to file time to file a report in the form of affidavit against the writ petition as well as the supplementary affidavit by the state respondent be further extended for 2 weeks hence. 2 weeks hence. 2 weeks hence. Let the matter appear in the list on 29th of July. 29th of July.
Grateful, man. Grateful to you.
Call the list. Next. 21 to call holo.
I am for the petitioner, my lord. State will give the report, my lord.
No report filed. You are for the petitioner. They have placed on record a report, brief history. Have you received that? Copy of report?
At Planet Senior, Sonal Senior is here, my lord, but she want to time for this matter, my lord.
Okay, not this week. Next.
Okay, my lord.
Not this week.
Last several occasions, your lordship was pleased to direct the respondents to file their affidavit.
Not filed.
Till today not filed. At least I have not been served. First of such direction was passed on 2nd April 2025. And on 14th May, your lordship was pleased to direct the respondent to file the affidavit preemptorily. Even then, I have not been served at least. The specific allegation against a particular food officials.
Second inquiry.
Yes, my lord. But a specific as allegation. Has been addressed to the respondent authorities by making a detailed representation. Page 59.
Your allegation is that second inquiry was done only to accommodate the private dispute.
Being he is the nephew or something of the food officials. Okay.
Lordship, there was a direction to file a report, Lordship. Pardon me, Lordship, there was a direction to file opposition. I have said report, the opposition.
Yeah, let me go through this at least. Just now I have received.
Use exception if any.
Reply.
Reply.
It should be reply.
Affidavit in opposition.
Yes, opposition.
They have filed the affidavit in opposition.
Okay, okay. Please take down. Affidavit in opposition on behalf of respondent number 1 to 5 be taken on record. Petitioner is at leave to file reply if any against the report
কি হলো কি দিচ্ছে হ্যাঁ
within 2 weeks from date.
Reply দেবে
এটা কত নম্বর
24 sorry sir
Let the matter appear in the list under the heading to be mentioned.
সন্ধ্যা হয়ে গেছে হ্যাঁ
30th July
2020 আর কিছু আছে নাকি ডাক দিতে না তাই
क्यों नहीं? Not this week?
I'm for the petitioner report will be.
Yes.
My lord, I'm for the petitioner, my lord. State will be the
Who is for the state?
My lord, I am for the state, my lord, the report is ready, my lord. My lord, may I either pass over or not today?
Only the not today if you file the report tomorrow.
My lord, ready, it's ready, my lord.
Very well. Not today.
Your Lordship, I'm appearing on behalf of the petitioner, Your Lordship. The state has to file the report in the form of affidavit. So in first, if you kindly see the order dated
2nd of April.
2nd of April and an order dated which was passed by Your Lordship on 10th of June of 2025. The state authority has taken time to file a affidavit. So I'm led by London Senior Advocate, Mr. Roy.
But we are in default. I'm candid about it.
Yes, Mr. Dotto, when can you file the report?
My Lordship gives me a fortnight's time, my lord, I'll do it.
খুব আটকে আছে কোনো ইন্টারিম অর্ডার
7 to 10 days time may be given because in this matter there is no interim order also.
There is no interim order.
If they appoint somebody else, my lord, then my lord, my petition will be infractuous. Kindly see the first order passed by your lordship.
2nd of April.
No sufficient go down to distribute ration articles. Very good. Mr. Dotto, learned senior counsel appearing on behalf of the Mr. Dotto, learned senior counsel appearing on behalf of the state, seeks accommodation for a fortnight to file the report, file the affidavit in opposition. Strong objection raised by.
Not strong, my lord, objection.
Okay, objection raised by Mr. Sahara, learned senior advocate on behalf of the petitioner. Having heard the submissions of the learned counsels, let the matter appear in the list. 21st of July 2025. Under the same heading.
Your Lordship may add
Under the heading to be mentioned.
to be mentioned. Lordship may add, my lord, strong and vehement.
Why?
First, I'm praying for not today.
Yes, you are?
No, I am petitioner. I'm for the petitioner. I'm praying for not today, Lordship.
Not today?
Yes, Lordship.
You have the report?
No, my lord, I do not have.
Come on tomorrow. Come on tomorrow.
Grateful, Lordship.
Not today.
Original का? 29, my lord, I am appearing for the state, my lord, may I be permitted to file the affidavit in opposition. Get a copy. Affidavit. बिल्कुल ना
opposition to other side ke dite
Your Lordship sees Your Lordship's last order, my lord, which was passed on 27th of March 2025, my lord. They were supposed to file their.
No, there is a delay, my lord. I
Well,
must
I'm not
admit, my
objecting
lord.
to it. I'm not objecting to it. And my lord, we were also directed to serve notice, my lord, upon the private respondents and them, my lord, because since none had appeared on that day, my lord, we've served them, my lord. This is the affidavit of service.
এইটা কি আমরা কখন দিয়েছি?
But I have just received the affidavit in opposition, my lord, by the state.
Yes. Please take down.
Lord, may I, my lord? Because one of the grounds, my lord, because what I can see, my lord, after just brushing through, my lord, the affidavit in opposition, my lord, is that, my lord, this is the usual affidavit, my lord, which is filed by the state in other cases, because I am an existing dealer, my lord, I have challenged a notification, my lord. So they've explained, my lord, as to what are the number of units that they would
Whether
be
you
detached.
use a reply or not.
Perhaps will not be required because they've not dealt with
Then
the.
if you are not required, I will fix the matter on hearing.
No, no, it can be heard today, my lord.
No, not today, my lord. I have to, my lord, I will cite some judgments on this, my lord.
Not required, my lord. Lordship will kindly
No,
hear
I
me.
require,
What he required, what you know.
I am
You will
supposed to.
require.
No. I am supposed to take time because affidavit is being served upon me
No,
today,
not
right
today,
now.
your lordship,
I am
it's-
saying that I'm ready. I will do the matter now, my lord. Perhaps
State is not ready today. If you are ready today, you can argue on that point. I will give it the time. He is not ready today.
I leave it to your lordship.
So when can it be?
Any day, my lord.
Kindly keeps it after a
Subject to your
week, my lord.
lordship's kind.
Kindly keeps it after a week, my lord. Because the main point involved here, my lord, that the person who's been given license, my lord, is a member of the Gram Panchayat and I have annexed documents regarding that. And that has not been dealt with by them.
Please take down. Affidavit in opposition filed on behalf of the state, being respondent number 124, be taken on record. Learned counsel appearing on behalf of the petitioner submits that he shall not use any reply.
So now that, my lord, they are seeking time, if required, I will. Yes, I am ready to argue now, but since they are taking time, why should I waste my advantage?
Very good.
If any, my lord, in the meantime, and I shall serve them in advance, much in advance.
Very good. কি বললাম বলো? কাটুন. Petitioner is at leave to file reply against the said affidavit in opposition within the adjourned date. Full stop. Next paragraph. Affidavit of service filed on behalf of the petitioner upon private respondent.
And the state.
And the state is taken on record. Full stop. Let the matter appear in the list on 15th of July 2025 under the heading to be mentioned.
Kindly records, my lord, despite service, none appears on behalf of the private respondent. Kindly records
Why
that.
record? No one is there, so how should
I have, that is why I have given the affidavit of service.
Yes.
Otherwise, there is no use of not filing affidavit of service. I have seen, my lord, addressee, my lord, item delivered to the addressee. I have personally checked.
Despite service, affidavit of service এর পরে লিখবেন affidavit of service টা বললাম না affidavit of service filed on behalf of the petitioner is taken on record করেছি ওর পরে despite service non appears on behalf of the private respondent record
Obliged, deeply obliged.
Grateful, my lord.
In item number 30, Lordship, I beg to appear on behalf of the petitioner, Lordship. We have served upon the state respondent, Lordship. There is a second round of writ application, Lordship. In earlier occasion, one writ application has been filed. So, Lordship will find from page number 43. Challenging one vacancy notification issued under the Control Order 2013.
in an area, Lordship, that is attached with the petitioner's servicing area. Now, Lordship, subsequently, there is an order of stay, and despite of that, Lordship, they have issued another vacancy notification as per the controller of 2024. Now, Lordship, there is no report of the controller of 2013 where the vacancy notification has been issued. And as the writ petition has been moved, Lordship, there is a stay of the operation of the notification. Now, subsequently, suppressing the entire material fact, Lordship, they have further issued a notification in a same area, in a same vacancy notification, Lordship. So, Lordship, I am on this point that whether they can further issue a fresh notification, we are until and unless that has been in earlier notification has been disposed of, it's stop its function, Lordship. That has to be declared by the state respondent. That one notification has been issued under controller 2013. We beg before your Lordship was pleased to direct to the they can continue with the selection process, but not to come with this conclusion. But subsequently, during pendency of the entire proceeding, Lordship, they have further issued a notification in the same area, Lordship, under the same location, same point, Lordship.
So what you want?
So I am asking for the stay of the operation of the vacancy notification, Lordship, and not come to the finality of the vacancy notification of as per the controller 2024.
How?
Lordship, that
This is
as
a separate order?
there is already a vacancy notification has been issued. That has been, Lordship, they are continuing with the vacancy notification. We came before your Lordship. We obtained an interim order from your Lordship that there should be no license should be given to the eligible candidates until the writ petition will be disposed of. Now, Lordship, when this notification is still in existence, whether they can, without giving the finality of this notification that we have already appointed someone or we have selected someone for the pendency of this particular order, they are not proceed with the same, they can come with a further notification in the same area or not? That is my question, Lordship.
So that is the new control order.
New control order, but Lordship, there is a vacancy notification.
This is the new vacancy, not new cause of action. This is the new cause of action.
New cause of action, Lordship, but either there is a vacancy notification that has not come to in conclusion, whether they can issue a fresh notification in the same area.
You challenge this on that writ petition, not this writ petition.
No, Lordship. কেন হয় না তুমি বিপটা আছো এই মামলায়?
May I request only one thing, since nobody is
তোমার
appearing,
appointment চাইছো?
nobody is appearing on behalf of the
You
state.
can appear.
I will appear, but still adjourn it for a moment.
I will satisfy your Lordship.
Just a moment. Let be ascertain who is appearing on that event. Lordship keeps it on the next date. If somebody doesn't appear, I will appear.
I can appoint you in this matter. No issue.
That your Lordship always do.
That's why you are here. This
I
is the
will come back
opportunity I
with
can
some judgment,
appoint.
Lordship, to satisfy your Lordship in this ground, Lordship. By tomorrow, tomorrow, I will come.
No, how can you challenge the earlier order? How
Yes,
can
your
you take the result of earlier order which was passed in the basis of separate notification?
But Lordship, the cause of action arose in the same area, same person is issuing the another notification. I am on that
Yes.
point.
Yes, they cannot
Of
issue. They cannot issue. You can
Yes.
challenge this point on the said on the earlier writ petition, not in the fresh writ petition.
Yes. No. It's a fresh cause of action, so that's why I
So
prefer
that's
the
why you
second
filed the. So
petition.
why you are asking for the recourse of.
So I will,
earlier
Lordship,
order.
I will come back by tomorrow and satisfy your Lordship on that point.
With Mr. Shubhasari.
No, I can.
If you have other reasons there,
Yes, your Lordship.
you can demonstrate. But this issue, I think,
I will satisfy your Lordship on that ground. I will satisfy.
not
Lordship.
tenable. I think.
I will satisfy.
Affidavit of service filed on behalf of the petitioner is taken on record. Full stop. None appears on behalf of respondent. State respondent. Full stop. Mr. Sumon Sengupta, who usually appears on behalf of the state and present before this court, is hereby appointed to do the matter on behalf of the to represent the state. To represent the state in this. Mr. Sumon Sengupta with another junior, with one of his junior. Usually represent the state. Be hereby appointed.
With a junior of choice and a copy of the writ
With a
petition.
junior of his choice. With a junior of his choice. To represent to the state in this matter. His appointment be regularized by the concerned authority in the meantime. So petitioner is directed to serve a copy of application along with the connected annexures thereto to Mr. Sengupta during the course of the day. Let the matter appear in the list day after tomorrow.
Your Lordship,
Day after tomorrow.
grateful to your Lordship. Instead of the Wednesday, can it be on Thursday? Because Wednesday, I have some medical problem.
Very well. So when can it be fixed?
7 except Wednesday, any day.
Thursday, Friday, I will take up another matters.
On that event, it can be taken
Monday.
up on the next week.
Next
Lordship,
week,
next week I have some difficulties. Lordship, after upcoming week, Lordship.
After Pujo.
No, not Sujo. Supreme Court থাকবো
Let the matter appear in the list on 22nd.
22nd. Grateful to your Lordship.
22nd.
আমি তো জানি না।
ওটা লিখতে পারলে? একটা স্পিডে বলে দিয়েছে। 22nd, next.
My lord, I am praying for not this week, my lord.
My lord, in this matter, my lord, I also had to file the report, my lord, that may kindly be extended, my lord. I have not done in this matter also. The lordship, my lord, directed to file short report, my lord. That may kindly be.
I want to know the total population of DRCs.
Yes, my lord.
Attached with the FPS of the petition. That is the only report I want.
Yes, my lord. I inform, my lord, only humbly praying, my lord.
Not this week.
Not this week, my lord.
Within week, is it possible? Okay.
Week, my lord.
Please take down. Learned counsel appearing on behalf of the state seeks accommodation for extension of time to file the report. After the matter be urgent today. List the filing of report by the state authority is hereby extended for a week. List the matter in the next week under the same heading.
I'm good.
Brother.
Next.
I appeared for the petitioner, my lord. I'm led by Mr. Shomo Mojumdar in this matter. My lord, the petitioner hearing has, my lord, challenged one withdrawal letter dated 19th February 2025 of his letter of intent. And also, my lord, the vires of the guidelines for reconstitution of LPG Distributorship 2022. To the extent, my lord, that the nomination by proprietor at the LOI stage has been mentioned to be only in respect of death and permanent disability cases, my lord, in contrary to the Rights of Person with Disabilities Act. My lord, an advertisement was flouted back in 2014, my lord, whereby in open category, pursuant to which, my lord, the petitioner had applied, petition number 1 had applied.
So your prayer in the writ petition number, prayer A, to declare that the guideline for reconstitution of LPG distributorship 2022 for nomination by proprietor at LOI stage only in respect of death and permanent disability cases to be contrary to the law, arbitrary against the provisions of right to. Okay.
Against the provisions of the Right to Persons with Disabilities Act. My lord, because it has been restricted only to death and permanent disability. My lord, I will show from the act, my lord, the definitions of disability. My lord, what happened in this matter is this, my lord. Pursuant to the advertisement back in 2014, the petitioner applied and my lord, it was in open category. And the petitioner was selected and letter of intent was issued in favor of the petitioner number 1 back in 30th March 2015 with a, my lord, clause over there, since there was a pending writ petition with regard to the, my lord, selection of candidature of another incumbent. The LOI has to be, my lord, LOI was issued and commissioning of distributorship, my lord, was to remain subject to final outcome of the writ petition. So, my lord, this was in back 2015. After which, my lord, the petitioner number 1 had taken all the steps possible. My lord, he had incurred, my lord, an amount of more than 40 lakhs, my lord, he had incurred for this, my lord, for constituting the Godown and, my lord, obtaining NOCs from the respective authorities. He had obtained NOCs. I have, my lord, annexed the documents pursuant to the steps which had been taken, which are at, my lord,
That is the peso license and everything.
my lord, 47 to 86, my lord, are the steps which has been taken. My lord, I have annexed the challans amounting to more than 40 lakhs rupees, which he had already, my lord, incurred. And also the no objection certificates, my lord, which your lordship will find at pages 92 to 101. After this, my lord, he had also, my lord, he had obtained the plan for sanctioning the Godown by, my lord, again incurring costs. The Godown photograph, my lord, is your lordship will find at page 137, which shows that the entire Godown, every construction, everything is finished. In the meantime, my lord, in 2022, the new guidelines for reconstitution of LPG distributorship came into effect, which, my lord, will find at page 146. My lord, I will refer to 2 pages there. My lord, before that, may I indicate, on 21st of September 2023, the pending writ petition, it went up to the Honorable Supreme Court and it was dismissed. Thereafter, your lordship, my lord, the petitioner's right, my lord, was transparent, because, my lord, the writ petition has not been, my lord, considered by all the benches. So, my lord, till 2023, my lord, I have taken all these steps. In the meantime, because your lordship will consider the situation, this petitioner has a minor, my lord, child in his home, and, my lord, he was already suffering from various medical ailments. He obtained one, my lord, disability. Your lordship will find the disability certificate annexed at page 144, my lord, whereby he was detected with mental illness, my lord, schizophrenia, 70% temporary disability. Whereas the 2022 guidelines, my lord, lays down criteria wherein, my lord, only in pursuant to death cases and permanent disability cases only, my lord, the nomination by, my lord, proprietor or reconstitution, my lord, criteria had been laid down. My lord, the petitioner number 2 is the elder brother of petitioner number 1. We had time and again, my lord, made representations that owing to this disability, kindly, my lord, considers, because we have incurred already so much losses, expenses, kindly considers and transfer the LOI to the, my lord, this petition number 2 being the brother of the petition number 1.
Petitioner number 2 is the brother.
Elder brother of
Full
petitioner
brother,
number 1.
Elder brother of petition number 1.
Lordship.
LOI was issued in favor of petition
number 1. And, my lord,
subsequently he appears to be the schizophrenic.
My lord, schizophrenia and 70% temporary, my lord, kindly comes to the disability certificate, which is, my lord, at page 144.
Okay. So you have challenged that notification.
I have challenged the, my lord, guidelines for reconstitution to the extent that kindly takes, your lordship, my lord, it starts from page 146, the guidelines. My lord, kindly comes to page 147. My lord, 147, my lord, clause 2, reconstitution at letter of intent stage. My lord, I will straight away go to, my lord, clause 2.3. My lord had got page 147.
Yes.
My lord, 2.3, my lord, it says reconstitution will be allowed at LOI stage in the event of death or incapacitation resulting in total and permanent disability, which will disable the LOI holder to work or follow any occupation or profession due to serious illness or accident resulting in total and permanent disability, which will disable the LOI holder to work or follow any occupation or profession. Reconstitution at LOI stage may be considered in favor of nominees or legal heirs or family members, including married children, daughter-in-law, son-in-law, and grandchildren, subject to their eligibility. In case if the legal heirs or family members or nominees as mentioned above have expressed their unwillingness, the LOI shall be cancelled after recording the said unwillingness in writing. My lord, thereafter kindly consider.
So you challenge this provision.
My lord, this provision to the extent that, my lord, it restricts only to permanent disability and death cases. My lord,
What is
kindly
the
take.
ground for challenge? Why you challenge this?
My lord, I have obtained, my lord, temporary disability.
No,
My
you
lord,
are showing some provisions of law
lordship,
that is derogatory to the rule.
lordship, my lord, before that, your lordship kindly considers page 176. This is also a part of the guidelines, my lord.
170?
176.
Yes.
My lord, the heading says applicable only in case of reconstitution cases where incapacitation resulting in total and permanent disability. My lord, this is where, my lord, this goes beyond the, my lord, statutory provision.
That is annexure E1. Annexure E1 of the said
guideline. My lord.
That is in response to the 2.3.
2.3, my lord.
2.3 of reconstitution and letter of intent stage.
My lord, thereafter kindly your lordship comes to page 144 is my disability certificate.
Yes.
My lord, the certificate your lordship will find the observations be my lord, fourth line. We are satisfied that he is a case of mental illness. B, the diagnosis in his case is schizophrenia. C, he has 70% temporary disability in relation to his psychological problem as per the guidelines for the purpose of assessing the extent of specified disability in a person included under the Act of 2016.
So whether you applied for reconstitution?
My lord, there is the question because the guidelines does not provide and that's why we cannot. My lord, kindly comes to page 137 once. Although, my lord, I have sent, my lord, several representation which are all, my lord, part of record. My lord,
130?
137. My lord, this is the complete construction of the Godown, which, my lord, I had completed back.
No, that is not the issue here now.
No, my lord, also
No,
the, my lord, financial, my lord, conditions are required to be considered. My lord, here I am challenging, my lord, the order dated 19th February 2025 at page 245. Whereby, my lord, my LOI was withdrawn. However, till 2023, my lord, the writ petition was pending. So, my lord, there was no delay on my part for all these years. I have incurred all the steps which had, my lord, which were required to be taken. And also, my lord, the monetary expenses also I have borne.
So this is the challenge in the writ petition.
My lord, this letter dated 19th February 2025.
That is altogether separate issue. What
Yes.
you are arguing at
Yes,
present.
yes, and also my lord, prayer A for my lord, I have challenged the vides of the guidelines.
Whether they have considered your prayer for reconstitution?
No,
Not
they
at
did
all.
not. They did
Not at all. They have considered
No.
yet.
The last representation, my lord, I have made on 3rd March 2025 after my lord cancellation of LOI. I have asked them.
No, LOI has considered withdrawal due to other reasons, as you have not performed within time.
My lord, these are also my contention. There are violations because, my lord, there is no question of performing within time. My lord, I have taken all steps. My construction is, my lord, is ready. I have incurred the, my lord, expenses. The challans are in, my lord, already, my lord, annexed in the
Then why
petition.
they should withdraw the LOI?
My
You
lord,
have to perform, you have to finish your Godown, motor, all weather motorable road.
License, which is a very
within
mandatory factor, it is not
PSO
let also.
license.
we have also,
everything you
yes,
have
my
to
lord, the
take
PSO license was also not granted. My lord, this is also another
My lord,
prayer. My lord, we have been running from pillar to post, but my lord, they are not. My lord, kindly comes to 2 documents, my lord. My lord, page 142.
So whatever may be, the issue involved is
My lord,
not
the issue-
required,
my lord,
not
I need to file an
required to
affidavit,
pass
my
an
lord.
affidavit is required to file.
Yes, my lord,
No interim order is
No,
required
my
in this matter.
because there are certain facts. which
Already withdrawal of AI has meant.
Yes, my lord.
My
Because
lord,
there-
my lord, I have prayed for an interim order that in the meantime, no third party right
lord,
may
that
be.
cannot
My
be
lord, this
granted.
much protection, my lord,
that
kind.
cannot be
My
granted
lord, kindly considers this case, this
How
person.
third party protection they would be.
My lord, how?
My lord, this person has obtained LOI back in 2015. He had been, my lord, doing or taking all the steps. My lord, I have enclosed the NOC also.
You are 25 now, 10
Yes,
years
but
as
because the writ petition was pending till 2023, and this was a
Let me
condition
say
in the
whether
appointment
you are
letter.
there in the writ petition.
No,
my lord.
Then
No,
why,
I was added.
who
I was
bind
added.
you?
My lord, yes, I was added.
Who bind you?
My lord, the appointment letter, my lord, kindly comes to the appointment
My lord,
letter.
the writ petition is replete with certain facts which are not germane to the situation. There has been suppression of facts. The writ petitioner had been engaged, is meaningfully employed in an employment which the writ petitioner.
My lord, I
admits
have
on page paragraph
read.
21.
My lord,
The writ petitioner, my lord, kindly sees is a teacher, is an assistant teacher from February 2024 in a school, my lord. That was also subject to very, my lord, discovery.
And this
at the
was
oil marketing
and
company.
this was intimated to the authorities. My
My lord,
lord,
this
they
was
cannot deny it. My lord, this was
is
intimated
also
to
a
the
violation
authorities.
of the rules and regulations, my lord, of the guidelines, unified guidelines, and also the brochure. My lord, there are a number of breaches of contractual provisions, my lord, in this particular situation. I'm humbly praying for filing my affidavits, my lord. There's no scope for interim order. The writ petitioner has not come with clean hands, my lord. It's replete, my lord. There is no PSO license as on date. Repeated letters have been addressed, my lord. I'll all disclose
My lord,
those
kindly
letters and
considers page
affidavits.
142. My lord, 142 is the authority's letter itself.
My lord, in any event, the withdrawal letter has not been challenged in this petition. They are challenging the wider, so there is no
Lord, the
scope of,
also
so there
been
is no
challenged.
scope of interim order at least.
No, my lord, the withdrawal letter, my lord, kindly
Withdrawal letter has not been challenged.
my lord, my lord, kindly comes to the prayer. Certiorari, my lord, we have certiorari and B and C is, my lord, for setting aside the withdrawal letter. Page 24 and 25.
19th of February.
Yes, my lord.
My lord, this is a public utility service, my lord. Any interim order by the honorable court, my lord, will jeopardize the entire situation, my lord, because the writ petitioner has been sitting tight for a long term. My lord, there is no PSO license, which is the primary.
My lord, page
primary
142
license.
kindly considers once. My lord, this is the, my lord, intimation which had been made by the HPCL. They say that we cannot answer why PSO is delaying your license.
My lord, that is not.
As it is an independent body. You please talk to them. My lord, where will this incumbent go?
My lord, the OMC is not supposed to give the PSO license, my lord. My lord, kindly appreciate.
My lord, he
It's a
had been
long
running
time, my
from
lord.
pillar to post. My lord, all the representations are here. He had been asking,
2016,
like,
the LOI is there. The oil
intimate
company
me what
cooperating
steps.
with the petitioner. Thereafter,
I understand.
deeply obliged, my lord.
My lord, kindly gives me some protection, my lord, because my lord, I have been working and I have been taking steps long, and there has been a huge amount of money which my lord is involved. He had been without any job, my lord, from 2015 to 2020. too, my lord. Kindly also considers this. My lord, he has a family. He has his old parents and a child to look after too.
My lord, there's a job which he's performing and that has been subject to
That is subsequent. I have pleaded this because, my lord, he had to.
guidelines.
My lord, he had to, my
That is
lord,
also
take care of his family, and this was intimated to the authorities as well. We don't, my lord,
kindly appreciate
deny
the
it.
fact that
Just wait, both of you cannot argue on that.
yes, my lord.
My lord, he claims himself to be a permanently, temporarily disabled and he is serving in a school. This is the attitude of the petitioner.
My lord, the certificate
Being a-
has been
being a-
issued
being
by
a
the
temporary
competent
petitioner,
authority. It has not been
serving in
issued
a
by the petitioner.
Yes, my lord. That is primarily a very important submission, my lord.
Very good. Please take down. Petitioner applied for LPG distributorship license in terms of a notification, in terms of vacancy notification issued by Hindustan Petroleum Corporation Limited. Petitioner was successful in the draw of lots. Accordingly, after FBC, LOI was issued in his favor on 30th of March 2015. It is the contention of the petitioner that litigation was pending in respect of the said location between the other between the HPCL and other persons. Accordingly, the petitioners could not proceed to conclude the conditions laid down in the LOI. Subsequently, by the letter dated 19th February 2025, the LOI of the petitioner was withdrawn by HPCL. It is the contention of the petitioner that the act and action of the respondent authority in withdrawing the LOI is arbitrary. Full stop. Petitioner also argued that the guideline for reconstitution of LPG distributorship, 2022, or nomination by proprietor at LOI stage only in respect of death and permanent disability cases is contrary to the provisions of right of persons capital with disabilities within bracket RPWD Act 2016. Full stop. The petitioner submits that in the terms of LOI, the petitioner has already performed the conditions, that is, he has already constructed the godown and a huge amount of money has been expended. At this juncture, petitioner seeks an interim order so that no third-party interest may be created by the respondent authority. Full stop. Next para. Respondent authority. Now, HPCL, represented by Learned Counsel, submits that the writ petition itself not maintainable by due to suppression of some material facts. It further submits that the LOI has already been withdrawn. So at this stage, no interim order is possible. Having heard the Learned Counsel for the parties, also considering the annexures thereof, it appears that the instant writ petition can only be disposed of on affidavits. Accordingly, the respondent authority is directed to submit the affidavit in opposition against the writ petition within 2 weeks from date. Reply, if any, by the petitioner within 3 weeks thereafter. Let the matter appear in the list under the heading of to be mentioned on 6th of August. Full stop. Having considered the submissions, rival submissions and rival submissions of parties, and also considering the merits thereof, I find no justification to issue an order of interim order. Pass it.
My lord, only one submission.
Yes.
My lord, para 21, my lord, is disclosure of the contention that he has been employed, my lord, subsequently. My lord, there is no suppression in the writ petition.
My lord will kindly take page 143 for half a second.
I have taken only submissions.
No, my lord, kindly take page 143. Just for 1 minute, my lord. The petitioner has said that the petitioner has applied for PESO license. The PESO is not considering. My lord, my respectful submission before my lord is that the PESO has once rejected its license. The petitioner himself, before the Honorable Court, my lord, has averred an affidavit with the writ petition wherein petitioner himself is submitting, my lord, the PESO has rejected the license because of certain non-compliances. My lord, page 143 of the volume 2 of the writ petition, my lord. My lord, kindly see, my lord, the proposal is rejected as point-wise compliance of this office letter dated 15 February 2024 is not compliant. My lord, this is a very important license, as my lord has rightly observed, my lord, that the fire license and the PESO licenses are primary things. My lord, in that event of the matter, my lord, I'm humbly praying, my lord, the writ petition.
Okay, file affidavit. Okay.
My lord, keeping it on.
6th of August.
And I'm led by Mr. Shomu Majumdar.
I'm good.
But I'm for the state, there was a direction to impede the private respondent in his favor. The license had been allotted. I do not know if that's been done. Sir,
And I appear for the private respondent.
For a change, I am supporting Mr. Huda.
For a change, I'm being supported by him.
Yes, where is the private respondent?
No, I am the private respondent. That is why
You are the private respondent. Who is the petitioner?
He is not.
I thought you are the petitioner.
That is why he said, for a change, we are on the same side today.
Mr. Badrul Karim.
Petitioner
is not there. No, whether he have filed any application for addition of parties?
No, Lordship had given them leave, my lord, to, my lord, add me as a party and serve. So they have done.
So the allegations were against my learned friend, which is why he was a proper and necessary party.
They have not, my lord, yes. They have not added, my lord, the private respondent as a party. Well, I am the successful candidate here. Okay. License has been issued in my favor.
What is your name? Asamuddin.
Assam.
Okay. Respondent number 9. Please take down. Then appears on behalf of the petitioner. State is represented by learned counsel. Private respondent number 9 is also represented by learned counsel, Mr. Huda. Let the matter appear in the list next week. Under the same heading. Not another heading to be mentioned on 14th of July. 14th of July.
Grateful.
Monday. No one is appearing for the petitioner. That's why.
Sure.
Next.
Would I beg to appear on behalf of the state, my lord?
On behalf of the private respondent.
Same issue.
Same issue, my lord. The petitioner is an unsuccessful candidate. He got 71 marks. The successful candidate, Mr. Huda, got 81 marks. Millet complying the every millet formalities as laid down in the vacancy notice, millet, we have conducted the inquiry. Millet, the entire the inquiry reveals that his Godown is lesser than the millet Mr. Huda's Godown in compared to that. And as well as millet, the other marks we have given, in total it coming up 81. There is a 10 participant were participated in the proceedings. The successful candidate got 81. The second unsuccessful candidate got 71. Millet, the unsuccessful candidate come up before your lordship saying some frivolous allegation that saying this has not done, etc., etc. Millet, this I do not think, millet, is a good case to millet entertain.
Very good.
Let's check down. There is nothing specific, millet. No specific allegation.
Down Monday. As the petitioner is not present, that's why I think Monday to under to be mentioned.
My lord, I am for the petitioner.
No.
I am led by Mr. Subhasati Chatterjee. He is engaged in another court, so I am paying for not today.
Not this puja. Pujar pore dicche.
Not this week. Very well. Okay. State is represented by Mr. Sengupta. Full stop. Respondent number 9 is represented by Mr. Huda. Petitioner 6 accommodation. Next para. Mr. Sengupta argued that there is no merit to entertain the instant writ petition. The respondent number 9 is the successful candidate who got huge mark in the selection process.
Kindly specify 81. He got 81
marks in selection process, while the petitioner has obtained has scored only 71 marks.
71.
Considering the situation, the matter be adjourned today. This is the matter on Monday under the heading 2 mentioned.
My lord. নামটা দিয়েছিস? হ্যাঁ।
Call the next matter.
35, my lord, I am appearing for the state respondents, my lord. May I be permitted to file the report, my lord?
Who is for the petitioner?
Yes, my lord, I appear on behalf of the petition.
Okay. Copy. Have you received the copy?
No, I'm
have a copy.
Yes.
WhatsApp notice.
My lord.
So you will read the report and.
My lord, subject to lordship's kind sanction, may I submit one thing? That was an admitted fact. For such reason, I have approached this court that it has been found that there was an incomplete bid. And thereafter, my lord, I have submitted before your lordship. My lord, if a fresh inspection can be made, my lord, because my lord, they could not allot the same to anybody only because of that, the area in concern, only the sole person I have applied for. That is admitted fact. If any official inspection be made now, as of now, my lord, it has been completed, subject to your lordship's kind sanction, then they are entitled to allot the same. If your lordship feels that.
But on the date when the initial inspection was made,
we have admitted.
That is on 3rd of October 2024.
We have admitted.
The authority found that the Godown was incomplete. That is why his candidature was rejected.
We have
That
admitted.
we have, my lord, annexed all records and documents and photographs.
No, if it appears that the candidate only he is the candidate, so apart from going to further process or issuing
But
further notifications.
My lord, I was told I have to take instruction, my lord, as to whether anyone has been appointed or not. If it has not been done, my lord, I can take instruction.
What is your report? Whether anyone
No report, my lord, that has not been indicated.
Why
Whether
not?
someone has been engaged or not, it is not there, my lord.
been
It is only, my lord, indicated as to why this application has been rejected. It is only on that.
Because, my lord, it is apparent from the findings of the final page, that is inquiry report. And more or less, my lord, if your lordship kindly sees the photographs that has been taken, it appears, my lord, in the month of October, that was the scenario. But by the end of February, by the end of February, my lord, we have completed.
I can take
Now,
instruction and can.
yes,
my lord.
that can.
What is the norm regarding incomplete?
My lord, if it is, yes, my lord, I have annexed it, your lordship kindly, the last.
If the floor, that means roof is not complete.
My lord,
it is
as
said to be incomplete.
my lord, that is, my lord, your lordship kindly consider the second last page, my lord. I have, my lord, annexed the memo dated 5th June 2024, the second page of that memo.
Yes,
My lord, kindly consider Roman 5.
yes,
The applicant applying against a vacancy of fair price shop must have a ready go down as per the above norms on the date of inspection.
yes.
However, if the go down is otherwise ready, following deviation or exception at the time of inspection may be ignored. A. If the structure of floor, wall and roof of the proposed go down is complete and floor is otherwise ready but the cement finishing is not done, or if the bitumen coating is not done in case of roof covered with asbestos sheet tin, then go down will be treated as incomplete but application would be proceeded. In such case, the minimum marks would be given for such go down. Then B, on processing of the application in cases of incomplete go down, if the applicant is otherwise found to be eligible and all other criteria of engagement of FPS dealer are fulfilled, license will be issued only after further inquiry and uploading of photo regarding completion of tiles, cement finish or bitumen coating as the case may be. However, in any of the wall or floor or ceiling or roof is incomplete on the day of the inspection, the go down will be treated as incomplete and the application will not be further processed. It will be marked as incomplete go down.
Roof is incomplete, then
Roof is, and my lord, the wall or floor or ceiling. Now, my lord, may I just complete this sentence? My lord, incomplete go down in the portal and size and pictures as on the day of inspection will be uploaded. However, no marks would be allotted against such applicant and he will be treated as ineligible. Now, your lordship will find that on the date when the inspection was conducted, kindly consider the last photograph, this one.
Yes.
Now, here, my lord, your lordship will find that the wall or floor or ceiling, this is incomplete, my lord. There are no plaster, nothing. Admittedly, this is an admitted fact, and my lord, your lordship will find from the report that this is, your lordship will find.
Okay, we submit report within the next week.
Very well, my lord.
Next week, whether what is the status of the present vacancy notification?
Very well, very well.
Whether anyone was appointed or he
Very
is the
well.
only person.
Very well. এখন তোমার কমপ্লিট হয়ে গেছে?
হ্যাঁ, as of now complete, মানে 23শে জুন যেদিনকে রিপোর্ট ওনারা করেছেন, সাইন করেছেন, ওই দিনকে ওনারা ইন্সপেকশনও করেছেন।
সেটা এখান থেকে পাচ্ছি না।
Yes, exactly. They did the inspection. It has been signed on 23rd June. On the day itself, they went there. Because I have the photograph on 23rd June that they are inspecting. যাও আমি যাচ্ছি।
Please take down. Inquiry report. Report in connection with this case. Report. Report on behalf of the state authority is placed on record. It appears from the report that the go down, proposed outcome go down of the applicant was incomplete at the date of inquiry. It further appears that there are 9 applicants. Full stop. The report is silent about the status of the present notification. Accordingly, the state is directed to submit a short report regarding the status of the notification within a week. List the matter Monday.
Very well. Next month.
14.
My lord.
Let the matter appear in the list under the heading to be mentioned.
My lord, I'm grateful.
I appear for the state.
I'm for the petition. I'm praying for not this week, my lord. There's some difficulty. On 14th, my lord.
We had submitted our report. Lordship had recorded rather, that the report is quite comprehensive, asked us to serve the petitioner with one. They were supposed to get back, and today was the date fixed. They have neither got back to us with any reply. I don't know about the private respondent. Today was the next date fixed.
Okay. So you are the petitioner.
I'm for the petition.
For the private in the license, I'm running my.
Okay.
Already running business. Report clearly reflects that it's the same case, Lordship, that Lordship was hearing all this while. Like inquiry report suggests that he is eligible because his area of the Godown and all other requirements in all respects exceeds that of the.
But my lord, where the Godown is, my lord, constructed, this land is not, my lord, the private respondent, my lord.
No, we already have
the land
submitted.
is estate.
Of the state, yes, this was a plot of land where I have never applied for, where I have never constructed, which was never been inspected.
Very good.
State report is the.
Come on, Tuesday, next Tuesday, under the heading to be mentioned.
Tuesday.
My lord.
Grateful, Lordship.
Tuesday week, yes. Petitioner 6 accommodation. According the matter is urgent today. Planet Council appearing on behalf of the state submits that the report, detailed report has already been placed on record. The instant petition is not required to be entertained. Considering the submission, let the matter appear in the list on 15th under the heading to be mentioned.
Grateful, Lordship.
Your Lordship, in item number 37, so I beg to appear on behalf of the petitioner, Your Lordship. Your Lordship, as I have been instructed by the Your Lordship, the advocate on record, he is the Your Lordship in court number 35, the running matter, Your Lordship. So therefore, Your Lordship, I have been instructed by the advocate on record that Your Lordship, there are some incurable defect appearing in the petition, Your Lordship. Your Lordship, I have been instructed, Your Lordship, that to Your Lordship, pray Your Lordship to withdraw the petition with a liberty to file a fresh.
So you are not the advocate on record. Are you
No,
the
Your Lordship, advocate on record is there in the court number 35, Your Lordship, in our running matter. So kindly, Your Lordship, if Your Lordship allowed to withdraw the petition with a liberty to file a fresh.
Advocate on record has
or
to
Your Lordship, I am praying for a short pass over.
pass it over. Pass. Next. Tempo. Yes, call item number 3 and 4.
My lord, I am sorry, my lord. I requested your lordship, my lord. I was engaged, my lord, in other court.
Yes.
আমার হয়ে গেছে একটা রিপ্লাই
No, my lord. In reply,
yes,
my lord, to my case and also, my lord, to the case of Buddhadev, my lord, lordship has already taken note of the fact that this case is guided under 2003 control order. That is undisputed. So far as right of Buddhadev is concerned, my lord, my preliminary objection is this,
that he has no locus.
Yes.
He doesn't have any right to entry. If he doesn't have any right to entry, well, he doesn't have also a right of audience. Now, your lordship has also taken a note of that so far as his case is concerned, he takes a point, my lord, that it has to be considered under 2003 control order. But in so far as rights are concerned, he takes a stand wholly contrary. He say in 2013, my lord, grandson also included. Now, my lord, he cannot take, my lord, two boats at the same time. Here, my lord, we are not on the case, my lord, that what 2013 stands. I also, my lord, I put your lordship in trouble to look into the 2003 control order and also, my lord, 2013, and, my lord, explain the difference. What relates to compassionate appointment is there in 2003, that is not there in 2013. The law itself is entirely changed. So far, the reliance of the learned advocate appeals for the state is concerned with regard to rejection and, my lord, saying that extreme financial crisis has sufficient means of subsistence. This was not, my lord, the ambit of 2003. He submits on the scope of 2013, which we are not. There is no answer by the state respondent that why my right of candidature, my lord, could be refused.
They have said you have applied for 2013 control order. Your application says.
My lord, I said that they insisted that you could not apply. I showed, my lord, kindly takes up that particular page. What I have showed to your lordship, that they have coerced me, my lord, that you could not apply under 2003 and you have to apply under 2013. My lord, kindly comes to, my lord, takes up, your lordship has already also taken note of it. Kindly comes to, my lord, page . May I just have a moment, my lord? Let me just. In their ballot affidavit in opposition, possibly. এটা বার করতো ডকুমেন্টটা কোথায়? ওই যে আমাকে বললো যে 2013 কন্ট্রোল অর্ডার অনুযায়ী অ্যাপ্লাই করতে হবে। My lord, subject to corrections, my lord, I have filed certain documents. There, my lord, kindly see, my lord, I have shown also the no objection certificate filed by all the legal heirs, including Buddhadev, and also, my lord, I have filed a document whereby, my lord, they insisted upon to furnish, my lord, the entire details in Form C. My lord, there are certain, my lord, documents which, my lord, I handed over the last day. There is no objection certificate filed by all legal heirs by my elder brother, including Buddhadev.
And you have also filed no objection.
Yes.
The case of.
Yes.
Case
Have your
of-
lordship found that document, my lord? Or if your lordship kindly, my lord, give me your lordship's brief, my lord, I can find it out. And your lordship has also taken note of that. These are not part of a affidavit, my lord, a certain few documents. Those are admitted, my lord. State also didn't deny.
Okay, proceed.
Has your lordship found, my lord?
No.
My lord, may I have the record? একটু জজ সাহেবের কাছ থেকে রেকর্ডটা একবার দেবেন?
রেকর্ডটা দিন না।
এটা কি বিশ্বনাথ না বুদ্ধদেব? Along with this judgments, my lord, I filed. আরেকটা রেকর্ড আছে? Here, my lord, those are not there, but along with this judgment, I filed all this stuff.
Along with the judgments you have placed?
These judgments were filed by us.
Yes.
The other records, my lord, so far as Buddhadev is concerned,
All the matters are there. All records, all documents. Nothing left.
গুলো কোথায়?
State has argued that why you applied under control order 2013. This is the argument of state.
My lord, that is the argument, my lord, I have heard, my lord, I have taken note of that.
Yes.
So far as the order is concerned, Justice Bose passed in 2014. That is very clear, my lord, the consideration has to be under 2003.
No, only two submissions are made by the
My
state.
lord.
One is why you applied for 2013 and second is delay of 7 years.
Delay of 7 years.
Yes.
Now, my lord, so far as, may I just take the second point first?
Yes.
Delay of 7 years. My lord, there is no estoppel in law. If the law permits me to apply, and since, my lord, the consideration as to be made in terms of 2014 order is still not being done. And if I fall within the, my lord, the definition of family members, my right is continuing.
Very well.
Had it been a case, my lord, that there was a consideration and it was finally, my lord, accepted by the honorable court and the post doesn't remain vacant, then my right goes. This is not something, my lord, estoppel in fact. This is an estoppel in law and there is no estoppel in law. If law permits,
Specific direction is there, you have to apply on a specific time.
my lord, so far as the application is concerned, my lord, those,
Whether any explanation is there, why you not applied on that time, within that time,
my lord, so far as in, my lord, in that case,
in your writ at least.
my lord, so far as my explanations are that, my lord, since, my lord, the post could not be, my lord, filled up. None of the candidatures, since, my lord, earlier Subhas was there, his candidature was not accepted. My lord, then Rabindranath,
Subhas applied,
yes,
you gave the no objection.
I gave the no objection, then I applied, then all other years, my lord, also gave no objection, including, my lord, Buddhadev.
So when
Now, my lord, if what I say that my right, my lord, that there is no extinguishment of my right because of, my lord, filing, my lord, delayed application, and this point subsequently has been taken up by the state and curiously adopted by Buddhadev at the time of final hearing. This has not been taken, my lord, even in the opposition. And, my lord, the judgment that I have referred, my lord, detailing, my lord, the point that so far the state is concerned, whatever they say in their rejection order, they cannot improve their case by filing an affidavit.
Yes.
Now, at this point, my lord, they have come up with this delay issue. Now, my lord, there is also a judgment of the Honorable Supreme Court which says, my lord, that if you want to say or urge on the delay point, that has to be taken at the very first instance. Your Lordship is well aware of the fact. There was no challenge as to my maintainability of the writ petition on the ground of 7 years or whatever XYZ years delay. This point was not kept open or in other way. While also admittedly, my lord, in the writ, my lord, so far as filing of a writ petition, there is no prescribed period of limitation. If my right continues, then, my lord, I have a right to apply. So, my lord, may I just sum up on this point, my lord, so far the delays are concerned, 2014 order, Justice Bose's order, my lord, did not attain finality. Finally, to the extent, my lord, the post still remains vacant. And I, being the legal heir of Gauridani Mukherjee, if I am otherwise entitled under the 2003 control order, then nobody can prevent me. If the post gets filled up and I remained as mute spectator, my lord, then, my lord, possibly, my lord, I could not have remained with any further scope, my lord, to come up. That none of the application of Subhash or else, my lord, so far as my family members was entertained, my lord, the series of, my lord, litigations were filed, and ultimately, my lord, I also filed, my lord, an application. And, my lord, that document I have handed over on the other day. My lord, today, my lord, I am asking for another copy where, my lord, I had insisted to file in terms of 2003 control order. Now, my lord, so far the 2013 control order, it was on their instance. And your lordship's, my lord, can my lord, take my words, my lord, that since I take the responsibility because I have personally seen that document and I personally handed over. And so far the other points that delay, my lord, is concerned, my submission is this: there is no estoppel in law. Even in Buddhadev case, I gave the consent, or in case of a Subhash, I gave the consent. That consent, my lord, otherwise, my lord, could not oust me, because Subhash also ultimately did not get, and Subhash, my lord, is no more. Now, so far as my right to apply still remains, and, my lord, in their rejection order, they have not taken any point that since you applied not in terms of 2014 High Court order, so we cannot entertain your case. If your lordship go back to my rejection order, this, my lord, is a, my lord, simply, my lord, it says you have enough regular means of subsistence.
Yes.
Page 49.
Yes.
That is the, my lord, basis of their rejection. I submitted, my lord, law is well settled that you cannot improve your case by adding some one more two grounds in your affidavit. Now the judgment, which is an interlocutory order, which even doesn't have any binding effect, my lord, passed by a division bench, your lordship may see that it entirely went upon clause 26 of the control order 2030, where my case is on 2003. The division bench order that the state respondent has submitted today relied upon a case of State of West Bengal versus Vishwajit Sen. There, my lord, the consideration of the division bench was that learned single judge ought to have considered 2013 control order and the clause 26. And that is the basis of their rejection in my 49. Now, my lord, takes the case again in a different angle. So far as my case, that can be considered under 2003, and Shubha's case, Buddhadev case can be considered under 2000. My case is 2013, and Buddhadev case can be 2003. This cannot be done. Both the case has to be done under the same control order. Now here, in my case, in order to oust me, my lord, what I understand from the submission of the state and Buddhadev, that they have come now in a, my lord, joint collusion and in a hodgepodge. These points were neither taken, even at the time of, my lord, opening the case, Buddhadev never argued this. Buddhadev had not taken this point even at the first, my lord, opening argument, that I do not have any right to apply. On the contrary, my lord, I made my opening submissions that Buddhadev has no locus, he doesn't have any entry. If he doesn't have any entry, one way, my lord, he says that, my lord, kindly considered my case in 2003. On the other way around, he says, my lord, I am included in the definition of a family member in 2013 control order. Now, my lord, the other submissions are this, that here the state says, my lord, that so far as my declarations are there, all are being done in terms of 2013. Then I would also say, my lord, the Buddhadev is concerned, they are also, my lord, application under 2013. Because they do not other way allow to apply informe. If your lordship kindly takes up the writ petition of Buddhadev, kindly takes up, my lord, page 56. Lordship has found, my lord. My lord, what the state does, my lord, he one way, my lord, tried to impress this court that we are following, my lord, the original order of this honorable court passed by Justice Bose. On the other way, my lord, they adjudicate the issue under 2013. Now, so far as my extinguishment of the right, as my learned brother appears for Buddhadev is concerned, I say, my lord, that there is no estoppel in law. I never extinguish my right. This is something, my lord, law permits. If 2003 control order applies in my case, and if I am the legal heir of Godown, who can prevent me, my lord? And so far as extinguishment of the right, if, my lord, for the sake of argument, I would say, my lord, I submitted that Buddhadev himself, my lord, gave me the no objection, which I filed before the authority. And I also showed, my lord, this filing of a no objection came up with much more stringent issues in 2013, where in 2003, my lord, the act was little bit, my lord, considerate, and it was not made so mandate, because it is something a procedural in nature. It would be better that I would have filed no objections. Lordship knows, my lord, if some procedures are being let down and the consequences are not being given, there is a hell and different, my lord, between 2003 control order and 2013 control order. This is my all submissions, my lord. I relied, my lord, few judgments, and I have all handed over except possibly, my lord, one judgment, my lord, 2015-5 SCC 813. My lord, on the issues of directive principles, my lord, that the duty of a state, 2015 volume 5 Supreme Court cases, my lord, page paragraph 9.
Yes. You have already submitted.
Already submitted. And, my lord, I also submitted, my lord, 2010 volume 10 SCC 677. So junior niye cheto. My lord, paragraph 32 to paragraph 34, the principle is if an order bad in its inception, it cannot be cured now. Then, my lord, 2003 volume 10 SCC 533, paragraph 35, the rule of reading down. Your lordship has also applied this principle, my lord.
Yes.
And, my lord, 2024 SCC online SC2, paragraph 26, a rightful claim cannot be deferred or denied due to mere technicalities. And admittedly, my lord, there is no other eligible legal heir. Buddhadev is not at all, and, my lord, eligible legal heir. And the last judgment that I referred, my lord, EIN 1966 Supreme Court, page 81, paragraph 4, that Article 226, my lord, the writ court is couched with the power to mold relief to provide justice in the peculiar and extraordinary circumstances of the case. These are the 5 judgments I referred, and I also, my lord, distinguish my learned friend's judgment, that which he referred, my lord, 2023 SCC online SC 640, that in case of an amendment, it's a retrospective. I say it's not an amendment, it's an entire new act. So he wanted to, my lord, draw an inspiration that amendment, while, my lord, clarificatory in nature, it should have been made retrospective effect. My submission, my lord, that does not apply in the given facts of the case. It was something, my lord, on an amendment. And this is, my lord, a 2003 and 2013 control. This is my case. I rest upon your lordship. And, my lord, those documents are concerned, my lord, I believe, since your lordship's file is that do not have that copy, my lord, may I be permitted to file those copies?
Yes, you can file.
কোথায় আছে সেগুলো বার করে দিয়ে দেবো।
My learned friend can, senior friend can file those documents since he has filed the affidavit. Right now he has said so that without, since the state has filed the affidavit, cannot act beyond that. Then my learned senior friend can also do that. I put that.
No, I submitted during course of argument.
Cannot. You have filed.
I
the
said
affidavit.
that there was a no objection certificate.
You have filed the affidavit without annexing those. Now you have handed over those documents to the during the course of argument.
My lord, whether something can be permitted in law, my lord, that's a question.
To myself.
Very good. Please take down.
Mine.
Argument on behalf of the parties concluded in both the matters. Made CAB.
Your lordship has all these 5 judgments or any?
Yes, I have one.
All the 5 judgments.
You have placed all the 5. All 5.
तीन है चार है
Vishwanath.
And my lord, those documents are concerned, my lord, we shall try to hand over by in course of the day or my lord at best tomorrow morning. I'm grateful. আমার আরেকটা আরেকটা নাম্বারটা দিলে নামটা কোথায়
Call the list.
My lord, I'm for the petitioner, my lord, praying for not
Praying
today.
for the state, Your Lordship.
Yes.
Praying for not today, my lord. I'm led by Mr. Timil Boron Shaha. He has not come to the
Not
court.
today.
Your Lordship kindly keeps it on next week. Your Lordship.
Not this week.
Not this week, Your Lordship.
Very well, not this week.
Okay.
Not this week.
Lordship, I am for the petitioner. The petitioner is suffering from fever. He could not come to the court and supplementary affidavit yet been completed. Therefore, I am paying for not this week.
Not this week.
And I'm for the respondent.
Your Lordship, learned advocate, Mr. Rahbar is appearing for the petitioner, and a death has happened in his family today early morning. So I pray for not this week.
Not this week.
I am for the state respondent.
On behalf of the petitioner, I'm only praying for not today, Your Lordship.
Who is appearing? Are you appearing on behalf of the petitioner?
No, Your Lordship. The advocate, the counsel is having some personal difficulties, Your Lordship. for
Very
which reason-
not today. Sure.
I'm grateful, Your Lordship.
I beg to appear on behalf of the petitioner, Lordship.
Lordship, this matter is pertaining to the controller of 2013, Lordship. Usual order may be passed, Lordship. The pendency of the division bench order, Lordship. This, in the meantime, Lordship, notes.
Have you
license
served?
have been- Yes, Your Lordship, I have served.
Where is the vacancy notification?
Lordship, yes, that is annexed, Lordship. Kindly come to page number 41, Lordship. And the legible copy of the same is on the very next page, Lordship, that is 42. That the vacancy which I am challenging, Lordship, Narhatta. It has marked and bold in page number 41, Lordship will find under the subdivision of Malda Sodor block English Bazaar, your Lordship will find from point number 7. That is the advertisement, Lordship. In the advertisement, in the middle portion of the advertisement, under the heading of subdivision Malda Sodor Block English Bazar. Lordship will find it has been marked, Lordship, that is point number 7. That the vacancy notification number under the Narhatta and the Lordship that under the Mouja George Gopal near George Gopal Primary School. And my license is annexed at page 39 as annexed P1, Lordship. And the very next page 40 is that showing that, Lordship, I am running my business, Lordship. That is issued on dated 1/1/2025 on the very next page number 40, Lordship. 39 is the license and 40 is the document showing that I am providing with the I am running the business, Lordship.
Your service area?
My service area, Lordship, within the Narhatta Jot, Lordship will find for page number 39. Having lawful possession of the Godown at village Narhatta, post Jot Bosonto, English Bazar, district Malda, within Narhatta Mouja, Lordship, the vacancy within the Narhatta, Lordship. Lordship will find for page number 39.
Narhatta is the GP, Gram Panchayat.
Yes, that is the
not the location of vacancy.
Location, Lordship, in the same. Location is same, Lordship. Mouja Narhatta. I am also from the Mouja Narhatta, Lordship.
Not Gram Panchayat is the Narhatta.
Mouja is also
Location
Narhatta,
is Mouja Jodh Gopal.
Jodh Gopal. Mine also, Lordship.
No, you are not.
That is referred as Jodh Bosonto, Lordship. State is represented, Lordship. State can clarify the same, Lordship.
Are you appearing in this matter?
Yes, my lord. কত এটা 10,135
10,135
Yes, my lord.
Within my service area, Lordship.
My lord, may I hand over my instruction, my lord? To your lordship, my lord.
Yes, read out, not hand over. What is your instruction?
My lord. Here, my lord. Petitioner, my lord. Son of late Monmohani Pal. My lord is partner of the Monmohani Pal and Sons. And the petitioner is aggrieved, my lord, for the declaration of the said FPS, my lord. The petitioner apprehensions, my lord, his volume of business would be reduced. Misconceived, my lord, it is, my lord, misconceived, my lord. It is a matter of record that pooling total is, my lord, 3329 DRC SWFs.
You
The
take
number
your
of,
breath and
the number of, my lord,
the report completely. What is stated there, you read it
my lord,
completely.
may I hand over, my lord?
Not hand over, you just your machine, you just read it.
My lord, I am reading, my lord.
Yes.
The petitioner Shankar Pal,
Yes.
son of late Monmohini Pal and Chandana Pal, partners of fair price shops, namely Messrs. Monmohini Pal and Sons, village Narhatta, Jot Basanto, English Bazar, Malda.
Yes.
The petitioners being aggrieved by the declaration of above said FPS vacancy issued by number such and such, challenging the said vacancy WPA number such and such before the Honorable Court. The petitioner's apprehension that his volume of business would be reduced considerably is misconceived. It is matter of record that the new proposed vacancies have been created by pooling total 3329 DRCS for the FPS vacancy number such and such from the petitioners. The online proposal for FPS vacancy is annexed, my lord, and the petitioners has tagged with 10,093 benefits consisting of such a 10,093 benefits has been, my lord,
tagged with him. The number of ration card holders which will remain tagged with the FPS of the petitioner after creation of new vacancies is 6764. Thus, the apprehension of the petitioner that the proposed dealership would drastically reduce his business is baseless and hard-faced. My lord, thereafter, my lord, the
That is not the
GOs have
point,
been
Lordship.
annexed, my lord. If your lordship, my lord,
There is
desires-
status, what is the status of vacancy?
what is the
Status of vacancy.
status of?
Vacancy, whether anyone appointed?
No,
My
my
lord-
instruction is that no one is appointed.
My lord, that I have to take instruction, my lord. My lord, this report, my lord, is dated,
So far, the controller
my lord,
2013 is concerned, Lordship. What they are submitting is baseless, Lordship.
7th May 20 দেওয়া আছে 7th May 2020.
Your report is 7th May.
Yes, my lord.
Old report. 7th May. Why? When you filed the writ petition?
It was filed.
2nd May. 2nd May. Now you are.
My lord, total beneficiaries is, my lord, 10,093.
That is not.
Total beneficiaries is, my lord, 10,093.
It was
my lord.
affirmed on 30th and filed on 2nd, Lordship.
That is not the issue here.
That is not the issue.
My lord, if your
Whether they
lordship,
can
my lord,
proceed with
desires,
the
my lord, I
2013.
can bring fresh report, my lord.
My lord can only ask this question that whether a license has been issued in favor of someone or not. Lordship was on that question.
Only that.
That
My lord,
part
I
is one.
have to, my lord.
Lordship, then the usual order may be passed with an stipulation that if had not been awarded to someone, Lordship, that can be marked, Lordship. If not awarded, till date, Lordship.
My lord, may I? My lord, may I come back with a short report, my lord?
So in the meantime, Lordship, if someone has been given, Lordship, then not to act anything, Lordship, till he will
I have
come
to
back.
take instruction on that.
Overtake
for it,
by
my lord.
tomorrow, if it possible, by tomorrow.
I want to know whether anyone appointed or not. That
My
is the
instruction
only.
is that, Lordship, there is no
My lord,
one is
I
appointed.
have to take
Come on
instruction.
tomorrow then.
My lord,
Tomorrow under the same heading.
my lord.
Only not today, Lordship.
Only not.
And affidavit of service will be kept with the record, Lordship.
Yes.
One line order may be passed, Lordship.
Okay. Please take down. Affidavit of service filed on behalf of the petitioner. Affidavit of service filed on behalf of the petitioner is taken on record. Let the matter appear tomorrow.
Under the heading of to be mentioned,
Or-
or if not reached, Lordship.
Just wait. What are passing the order and you are directing this court to pass an order like. কি বললাম বলো? কিরম ভুলে গেলাম? Let the matter appear tomorrow. Tomorrow for providing for wanting instruction from the respondent authority. Tomorrow or cartoon wanting instruction from respondent authority. Respondent authority. Under the same head. Yes.
Lordship, if not reached, Lordship, I will mention, Lordship. If not reached.
It will appear tomorrow.
It will be reached, Lordship, but otherwise I will liberty to mention, Lordship.
Next.
My application, my lord, my compassionate appointment application has been dismissed, challenging that I filed this writ petition, my lord.
What is the matter?
Uh,
Item number?
44.
Call the item number 44.
44, my lord. I am a family member, a dependent family member. May have been married at the time of filing of the compassionate appointment application.
You are appearing online.
Yes, my lord. My lord, for the petitioner, my lord, I am led by Mr. Mr. Ghosh.
Who is appearing?
But he's my junior. He's
Okay,
assisting.
okay.
I am assisting.
I am for the statement.
You are for the state. Yes, what
But
is the issue?
the petitioner is the daughter of the deceased who died in harness as an FPS shop owner, my lord. Now,
I did in the year 2020.
2020, I made the application. Thereafter, there have been litigations, and finally, my application has been rejected. In fact, the daughter-in-law of the deceased also made an application that has been rightly rejected, but my application also has been rejected. The main ground for rejection was that I was married.
81A. This is the impugned order.
Right, I'll also come to the impugned order.
81A.
81A, my lord, Annexure P13. I'll rely on the documents I had placed before the hearing officer, and I'll try my best to prove that this is probably a perverse order and none of the documents placed before this officer has actually been considered. Observation, my lord, will kindly come to.
And kindly come regulatory provision, clause 3.
My lord. I'll show from this provision that I am eligible. As per West Bengal Public Distribution System Maintenance and Control Order 2013, in the case of the demise of a FPS dealer, any dependent family member can apply for the license. However, the application must be accompanied with corroborative documents establishing dependency. In my case, my lord, I was dependent on my father. Yes, I was married, but at the time of making of the application, I was separated from my husband. Thereafter, it has resulted in the divorce. And in fact, the divorce decree will make it evident that at the time of making of the application, I was separated from my husband. The divorce decree specifically says that we were separated at least for 2 years prior to filing of the proceedings.
And no objection certificate was not submitted by the petitioner hearing, my lord.
Petitioner,
How
will I give a no objection certificate? I don't know.
Yes, your application was turned down as you have, both of you could not provide the no objection.
No objection certificate, she could not. But
the other legal aids.
I could, my lord, I could. But I'll just show the page number. NOC is at page 35. I had placed these are perverse findings. These were documents handed over at the time of hearing, for which I may not have a received copy, but these are perverse findings.
From the order sheet, it is clear, my lord, there is no perversity, my lord.
From the order sheet, if my documents are not even considered,
clearly it is written here, my
nothing has been considered.
No objection certificate was not
predetermined order has been pronounced. I am a family member. The daughter-in-law of the deceased could not have been a family member, rightly refused. But when it comes to me, I have. And why will I not? If I have no objection certificates, why will I not produce? If I have annexes to this petition, this is before an executive magistrate, my lord. It is not that I can conjure up these documents.
Column, page 81A, it's clearly written, my lord.
These are perverse findings, completely perverse findings. That is why I am.
Have you pleaded this, that you have produced this document? Have you pleaded this in your writ petition?
I have to see.
That this is the perverse finding, you have filed the document.
I have not directly, but I will kindly come to page 11, ground 16.
No, I want your specific pleading that you have placed this
there is no such
document. You have placed this document.
I can come up by way of a supplementary affidavit. May I come up by way of a supplementary affidavit? The pleadings may not be very specific.
Yes, when you have challenged the order, that is, it is perverse as document was not considered. So this document, page 35 only.
Page 35. 35 is a no objection certificate. Not only this document, there are other documents which have not been considered. In fact, my divorce decree has not been considered.
There is no mentioning about the divorce decree, my lord. You do not know whether there was any divorce or not.
Page 59. I can't conjure up a divorce decree. This is a decree by a court of law. How can I conjure up these things? Can I conjure up a divorce, decree of divorce?
Probably that was not produced before the authority, my lord.
Yes, whether you have produced it. I can come up by way of a supplementary affidavit. No, but I can show page 78. My lord will kindly see these. This is final notice hearing.
Thank you, Dover.
I'll come up by may I have your lordships kindly to file a supplementary affidavit. I'm under instructions that there are even receipted copies of these things.
That was not the part of the writ petition.
May I come up by way of a supplementary affidavit? This is my instruction from my learned advocate on record, that there are even receipted copies of these documents. Very good. On the prayer of the learned advocate for the petitioner. On the prayer of the learned advocate, the petitioner is at leave to file supplementary affidavit along with documents. Along with desired documents thereto. I make it clear that the supplementary affidavit shall not change. Then the supplementary affidavit, proposed supplementary affidavit shall not be allowed to be accepted. No, shall not be accepted. If it changes the nature and character of the instant writ petition. Otherwise, you can file afresh.
Yes.
But I'll come up. I'll not rely on any further documents. Just a receipted copy of these documents. Nothing else. Let the matter appear in the list on 29th
of this month.
July. Under the same heading. Shall not be accepted.
My lord, Passover item number 13 can be taken up.
Passover
item number 37, lordship. 37. Lordship, the matter was filed challenging the control order 2024, lordship, but the amendment which has been taken in the petition, lordship, are 2013. So, lordship, there is a enormous mistake, lordship. Let the matter be withdrawn and liberty to file a fresh, lordship.
Please take down
37.
On the prayer of the learned advocate for the petitioner, the instant duty petition is disposed of with a direction to the petitioner to sue afresh on the same cause.
Liberty to file a fresh, lordship. Grateful to your lordship.
Next.
My lord, item number 45, learned advocate on record engaged in courtroom number 35, my lord. I'm praying for just short passover. Kindly give me short passover, my lord.
16:30.
Lordship, he is on his way, my lord. Kindly give me short passover.
Not to make it not today. I'm for the private response.
Very well, not today.
Not, my lord, not to, just not.
Not today. Next.
Report. Praying for not today, my lord.
Not today.
Your lordship kindly keeps it in the next week, your lordship.
Okay, very well. Mr. Saha is there.
Yes, my lord.
Not this week. Next.
I am appearing on behalf of the petitioner, my lord.
Yes.
The affidavit of service.
My lord, notification issued for grant of license for ration shop dealership, my lord. Private respondent has been selected, my lord. Petitioner claims himself to be the most eligible person, my lord. Without assigning any reason, my lord, his candidature has been cancelled, my lord. Inquiry was held, my lord. But my lord, here the point is that the land shown where the godown exists, actually there is no godown at all. So a report is required to be filed. There are two lands. I have annexed the specific
Land
specification.
over which the proposed shop-cum godown of the private respondent was situated.
Yes, my lord. The land which has been shown, there is no godown at all.
In the application.
Yes, my lord. And another land which is of the father of the private respondent, which is wasted land, there, my lord, a godown exists. My lord, misguiding the authorities, my lord, they have obtained. So a report is required to be filed, my lord.
So this is your ground here.
Yes, my lord.
So
Otherwise.
And who are you? You are one of the applicants.
Yes, my lord.
And I appear for the private respondent, my lord.
You are appearing for the private respondent.
My instructions are, my lord, that the land that was shown, my lord, in the application is where the godown is situated. And in fact, my lord, the petitioner, my lord, the petitioner's godown, my lord, is situated on a patta land, my lord, and there are litigations with regard to that. I do not have all the documents, my lord. Lordship may, my lord, pass. And my lord, the license has been issued, my lord, and I am distributing food for the past 2 months, perhaps.
Okay. So who is appearing for the state? No one is there.
I do not see anyone.
Okay. Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Despite service, none appears on behalf of the state respondent. Private respondent is represented by learned counsel Mr. Huda. Full stop. Having heard the learned counsel for the parties and considering the read petitions and prayer thereof, it appears that the incident read petition can already be disposed of on affidavits. Let the state respondent use the affidavit in state respondent be at liberty to file affidavit in opposition against the writ petition within 3 weeks from date. Full stop. State respondents and private respondents both go. And private respondents are at liberty to file affidavit in opposition within 3 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Let the matter go out of the list. Parties are at liberty to mention after completion of exchange of affidavits.
Just,
my lord,
just one line, my lord, the point of maintainability we kept open because I am told, my lord, that my lord, the candidature of the petitioner was not at all eligible. Petitioner himself was not at all eligible, my lord.
Okay.
Totally, my lord.
Yes.
Instead of filing affidavit of opposition, my lord, kindly direct them to file a report whether any godown is exist at that relevant plot of land in which they have applied.
I will have to file an opposition. It's the same.
Either way, he has
Filed by the state, my lord. As per my instruction, there the land is vacant. There is no godown.
I will be
So
filing.
the
an
report would be
opposition.
sufficient. Report would be sufficient. Unless which they would be file a report in the form of affidavit.
That will only delay the proceeding. Because I'll be filing my opposition. Well, the first point that I will take is the ineligibility of the
If it
petitioner.
reveals that there is no
Only
godown.
particular report would be not sufficient. At least the report has to be affirmed. Unless which we cannot bind them.
And as your lordship.
Okay, not affidavit korun tale. Report in the form of affidavit korun.
By the state and my lord, me affidavit in opposition.
You are affidavit in opposition. State ta korben. Report in the form of affidavit. Opposition. A state দেবে report. Report in the form of affidavit against the petition. State to file a report in the form of affidavit against the petition within 3 weeks from date. Private respondent to file affidavit in opposition against the petition within 3 weeks from date. ঠিক আছে to another.
But
maintainability as raised by the learned counsel for the private respondent be kept open. Yes.
There is my lord, exception to the report if required, my lord.
That is only.
That is
Exception.
Double.
Next matter.
My lord, for the 48, Mr. Learned Advocate Timirbaran Shah is the
Not this
advocate on
week.
record.
Yes. নিয়েছো 49 59 বললে যেত 49 দে না বুঝতে দে Yes, no, my lord, admittedly, there is no scope for any. No, my lord, my claim, my lord, my application has not been considered. I raised an objection. Then they called for a hearing. My lord, I could not attend because of my illness. I informed that. Now, if your lordship directs, my lord, for a further hearing, so that I can matter can be. No, what is the issue here? Issue is, my lord, my lord, the MR dealership issuance of my lord license in respect of MR dealership. Very good. Now, my lord, I applied. Thereafter, inquiry, interview, everything has been conducted. I made an RTI application. My marks is low than the selected candidate. Therefore, I raised objection. Now, my lord, they fixed a date for hearing, but I could not attend this hearing because of my illness. I informed with by way of mail. Now, my lord, since I could not have attended the hearing, my lord, let a direction be given if a fresh hearing can be given to me. That is my only prayer, because there is no scope for any interim order, nothing else. Private respondent has been selected. What is the status of the vacancy? Already licensed.
License
Yes,
given, we are
raised the
also-
business.
We are also running the business.
Yes, yes, I said, my lord, at the
Execution
threshold, there
process
is no
started.
status. So when the notice of hearing was given to you?
Page 66.
Page 66. Page 66, my lord. একটু হেল্প করবে ভাই, আমি পড়াশোনা করিনি সেরকম। তুই আছিস তো? Personal appearance, 7th of May. My lord. You could not appear there. No, my lord. After all, my lord, after the complaint was made, my lord, then my lord, a further hearing was conducted, in which, my lord, I could not appear. Is there any order?
Page 66.
Page 66, my lord.
Yes,
This was the notice.
Hearing notice.
Yes, yes.
Is there any order?
No order. That has not been.
Not order.
I cannot, my lord, claim for any mandamus, because, my lord, there was, my lord, something, my lord, they said under the RTI that I obtained lesser marks than that of the private respondent. Though the license has been given effect to.
Well, that lesser marks has also not been annexed here. In my copy, I am not seeing this. তুমি কত মার্কস পেয়েছো?
আরে ইয়েতে দেয়া রয়েছে তো, পিটিশনে পর পিটিশনে দেয়া আছে।
পিটিশনে না।
My lord, page 74, my lord, I inform. Yes. As you have not reached there, so your hearing was not done. No, my lord, I could not, my lord, if your lordship kindly see page 74, due to my serious illness and poor health. I understand you have serious illness, but whether you have made only other applications that I want the hearing further. No such application is there, I think. For further hearing.
There is no subsisting list.
No, my lord, kindly see, my lord, 74.
74 is his grievances reconsidered. Once considered, rejected, he has been granted license. He wants reconsideration. If my lord is so pleased, my lord can direct that since license has been granted, it will continue. But his grievance can be heard. This much.
That I am trying to know whether after you could not reach there, whether you approach the authority. Yes, yes, on that letter, my lord, page 74. Page 74.
That may be reconsidered. Only thing.
Respected sir, my lord, I am placing. Due to my serious illness and poor health condition, I am unable to appear today. I would greatly appreciate if
if you could grant me a chance to attend up after 1 week. Yours faithfully. And the last paragraph. Sir, you have invited me for an interview on so and so. Due to my sudden and serious illness, I will not be able to attend on so and so date. Sir, I humbly request you to grant me the time on any working days.
The subdivisional controller, put and supply.
Yes.
Very good.
সেই অবজেকশনে তো আমি যেতে পারিনি হিয়ারিং এ, সেটাই তো ডিপার্টমেন্ট তো সেই কথাই তো বললো।
Subdivision controller Haldia. Yes, Haldia.
ডিপার্টমেন্ট স্যার তো সেই
Okay, please take down.
My lord, kindly consider only these two documents. My license and allotment.
Well, that nobody, I am not denying that.
Why you are disputing?
I am not disputing. I admitted that.
And you have
Okay.
you
okay,
make your
okay.
submission. I did not disturb you. Why you are disturbing me? You have done something for your client. I will also done.
Petitioner applied for FPS license
Already granted.
in terms of vacancy notification. Issued vacancy notification dated 15th of May 2024, issued by SCFS Haldia. Full stop. In terms of the said vacancy notification, private respondent was selected, and she was granted license. At present, the private respondent is distributing the ration articles to the beneficiaries in terms of the said license. Full stop. The petitioner has raised some objection against the candidature of the private respondent.
Page 48 of my petition.
By such, one hearing notice was served by the subdivisional controller to the petitioner, whereby the petitioner was directed to appear on 7th of May 2025.
Right.
Whereby the present petitioner was directed to appear before the concerned authority at his chamber, at his office at on 7th of May 2025. It is the contention of the petitioner that due to serious illness, he could not reach the office of the concerned subdivisional controller on the fixed date. Accordingly, he wrote he forwarded a mail to the authority to reconsider his case and be given him a time for further conduction of personal hearing. His mail was not replied, hence this writ. Full stop. It appears that learned counsel appearing on behalf of the state submits that the respondent authority has conducted the selection process according to the procedure of law under relevant control order 2013, on the basis of which the private respondent became the most suitable candidate. Consequently, license was granted in her favor. Now, private respondent is distributing ration articles in terms of the license. The further learned counsel for the state further submits that the concerned authority has considered the considered the representation of the petitioner and given him time for personal hearing. He could not appear. Full stop. Private respondent, learned counsel for the private respondent submits that private respondent being the most successful candidate, most suitable candidate, was granted license. There is suitable candidate was granted license, and there is no illegality in running the license. Full stop. Having heard the learned counsel for the parties, considering the entire issue involved herein, it appears that the petitioner at present has not posed or raised any question regarding granting license in favor of the private respondent. Petitioner approached this court only on the issue that he may be given sufficient opportunity so that his personal hearing can be done by the concerned authority. Having heard the learned counsel for the parties, considering the issue involved herein, the incident writ petition is disposed of, directing the Subdivision Controller Food and Supply Haldia being respondent number 5. Subdivisional Controller Food and Supply Haldia being respondent number 5 of the incident writ petition to allow the petitioner to allow the petitioner in personal appearance before the authority, which he was earlier granted. Full stop. The petitioner is directed to approach the authority coupled with the copy of this order within a fortnight from date for fixing a date of personal appearance before the authority. Full stop. Next, on such, the respondent number 5 shall provide the petitioner a sufficient opportunity of being heard through a personal hearing, which should be fixed within 6 weeks from the date of receiving of such representation. Full stop. Next paragraph. The respondent authority shall dispose of the personal hearing of the petitioner by passing a written order. Within 2 weeks thereafter. The decision of the authority shall be intimated to the petitioner accordingly within a week. Full stop. I make it clear that this court has not entered into the merit of this matter. Full stop. The respondent number 5 shall consider the representation of the petitioner according to law without being influenced by any observation of this court. Full stop. Since no affidavit has been exchanged between the parties, allegation made in the writ petition shall be deemed to have been not.
Lord, with regard to running of the fair price of Lord, to kindly make some observations.
Yes, I have made observations.
These documents that I said, these are the documents. Kindly see the very first document, my lord. I submitted in Form A in accordance to 2003 control order. They say that your submissions are not correct. File it in Form C.
Now, whether these are in writ petition or outside the writ petition?
Yes.
My lord, these were all indicated. These were all indicated during my lord course of argument.
I understand during course of argument.
And my lord, these are the documents. Filed, my lord, no objections.
These documents is not the part of the writ petition, not the affidavit.
My lord, it is not the state was very much present. State doesn't dispute. And state had a knowledge and notice of the fact. And these are the no objection certificate. The first one is of Buddhadev.
No, these has to be filed with the writ petition. How can I consider at this stage, sir?
Then, my lord, kindly permit me, my lord, to use a one-page supplementary just to bring it on record. The state has already, my lord, put on
No, I
notice.
understand, but at this stage.
No, my lord,
but-
it is not that after conclusion of argument I filed this. I disclosed it during course of argument. Even, my lord, Mr. Bhattacharya's junior was there. He had taken note of it. The state was present. The state
Is this document with the affidavit?
My lord, then kindly
The writ petition.
then kindly keep it.
These are the merit of your matter.
I understand, my lord, that kindly keep the
State
matter.
has raised objection from the beginning that your application is not.
No, the state has rejected my application because of
They
the
have
fact
rejected
that I
because
have
they are
I have sufficient means of subsistence.
Their opposition, they have said that you have filed the application under 2013 control.
No, that is not their stand. It is their stand, my lord, that I have sufficient means of
That is
subsistence.
the order itself.
Yes.
But the affidavit opposition, they have said.
No, it is not that.
I have seen such a.
Now, my lord, here, my lord, this document part say.
Not one document. You have placed several documents that has to be considered.
My lord, the next documents are already part of the record. Only the first document, that it is according to their directions, my lord, since they did not accept it. Now, my lord, I am before.
Whether this document is in the record. This document.
Yes.
Final reminder to submit.
No, first and second document, because, my lord, I was insisting that 2013 control order will not apply.
Assuming my learned senior friend is right, that as per instruction of the state authority, they have filed a 2013 control order. They have not raised any objection that without prejudice to my rights and conduct, I am submitting my application at 2013 control
My
order.
lord,
You placed with affidavit.
Very well,
it is
kindly
not possible for me.
Then, my lord,
Consider your.
then, my lord,
They made the matter CAV.
My lord, kindly then permit me. My lord, otherwise, my lord, I am before a court of equity. My lord, the equity, my lord, may not be delivered. My lord, I have come up with a good case. Even the state in his submission, because state had the notice and knowledge. Mr. Bhattacharya's junior also, my lord, had taken note of that. In their reply, my lord, they did not take this. State also did not say that there was no objection, and we did not insist.
Should not be placed in CAV.
Yes, my lord.
Kindly give me one option, my lord.
If I give you the affidavit chance, then they have to.
Then, my lord, kindly for the sake of justice, my lord, kindly, my lord, it does not require even hearing.
Nor in the opposition.
I would not, because they have taken this point. That is why this is very much necessary.
I understand, but they have to give in a chance to contradict your documents.
Then, my lord, kindly give them a chance. Because I also would not allow, but otherwise, my lord, justice may not be delivered. But lordship may either come in my client's favor or go against my favor. That's a different justice.
That is not the issue.
Yes, that is not the issue. Lordship is always kind enough. Then give me, my lord, 2 days chance, my lord, to come up with supplementary just to bring on record. Let them submit. I have nothing because I have already submitted. Kindly, my lord, at least, my lord, do, my lord, this much of indulgence, my lord.
C4 কে নিয়েছে আপনি C4 আপনি নিয়েছেন ওকে তাহলে সিএবি করেছেন তো ওটা কেটে দিতে হবে C4টা কেটে দিয়ে করুন ডিউরিং দ্য কোর্স অফ আর্গুমেন্ট
Extremely grateful, my lord.
I have heard this matter today thrice.
I'm extremely grateful, my lord, and really, my lord, it's lordship so, my lord, kindness and wisdom, my lord.
During course of argument, learned counsel appearing on behalf of the petitioner within bracket WPA 26887 of 2022 intends to use some document in support of the writ petition. In support of his writ petition. Let the document be placed on record through affidavit. Supplementary affidavit. Petitioner is directed to file supplementary affidavit within a week. Full stop. The copy of supplementary affidavit has to be served upon the learned counsel for the state as well as the petitioner of writ petition number WPA 13773 of 2019. Full stop. Counter affidavit by the state. Next part. Counter affidavit by the state or the petitioner within bracket WPA 13773 of 2019 be placed within 1 week thereafter. Within 1 week thereafter. 1 week, 2 weeks. Then Let the matter appear again under the heading 2 mentioned on 29th of July. Under heading 2 mentioned.
Extremely grateful, my lord.